Lord to mention, this is a Section 11 application. Your Lordship had initially appointed Mr. Shorbopriyo Mukherjee as arbitrator. Thereafter, Your Lordship changed and made it Mr. Royan Banerjee. But as it appears,
Banerjee also has difficulty.
Yes, Mr. Banerjee also is in difficulty. He appeared for us. So I'm carrying the order for Your Lordship.
Hand over and suggest a common name on the next option if you can.
I have
It will
given
appear as to be
notice.
mentioned. Please have a talk with your other
Very,
side.
very well, I'll do so.
It will appear as
May I
to-
have your lordship's leave to mention one matter? This is an application under section 11
Hand over.
for
Hand over.
for inclusion in the list. Yeah.
Which
Grateful, your lordship.
item number 3, I have in some difficulty. There's a matter fixed because there are only number 5 matters today. Because if it is also taken,
3 you want not today.
not today, it can be taken up on Friday. Because also I'll tell you,
Please
indicate-
keep somebody.
is there, my junior will
Yes,
be there.
that will do. That.
The only thing is, I'll tell you, Your Lordship, yesterday the Supreme Court has given a 5-judge bench judgment, which is everybody is being talking about is unstamped and all that. But it also has a
The unstamped I've seen that. I mean,
Yes.
in live law.
That is, in my humble submission, that is not an issue
That
because
probably
it is not an agreement in respect of an immovable property.
Your Lordship, that is
No,
not
that
what
is
I-
probably pertaining to the arbitration proceeding.
Your Lordship, no. I'll tell you, explain to that also. That judgment also, I today got a copy of it. I was looking through, has 20 paragraphs on section 11(6)(a). On what is the entire thing about section 11(a), the history, how it should be interpreted about the court. So the entire thing is being laid
Should
down.
be.
So now I will look into it and I'll
So formally cite it only on Friday. Before that, I'll
Yes.
pass some orders in the other matter. Very
very well.
well. Keep somebody, ask for time, I'll adjourn it till Friday. You are for the other side.
Yes,
That
I'm
way.
for the, it's my petition. Mr. Sinha is for the respondents.
My
Manoj, I'll
be
be
there.
You need not be there. I mean, yes, call on the list.
Listed matter, item number 1 to be mentioned.
Item number 1, I appear for the petitioner lordship. We are handing over a copy of the affidavit in reply, lordship.
Serve করেছে This is the same
আচ্ছা,
thing.
Same, just notarized.
আচ্ছা সিবি তো হয়ে গেছে অলরেডি আচ্ছা the original reply filed by the petitioner he kept on record বাস this was আর কিছু না। আগে সিবি হয়ে গেছে
ফাইলটা নাবা পরে রাখবি। Item number 2, new motions. Student ARC.
May it please your lordship.
yes
My lord, I'm appearing on behalf of the petitioner.
Right.
My lord, in this application, which is
Hey,
for
hey,
appointment
Babu.
of an arbitrator, my lord.
একটুখানি না এইটা মুখের সামনে থেকে সাইডে করে দাও, একটু সাইডে করে দাও, যাতে আমি দেখতে পাই কিন্তু মুখগুলো ব্লক থাকে সরি প্লিজ কন্টিনিউ yes
Yes, my lord, on the last occasion, your
this
lordship,
is the one where that there was a
clause
previous
13,
clause
my lord, and your lordship had pointed out whether we had exhausted that particular
right.
pre-negotiation prior to institution of the invocation of the arbitration.
True.
My lord, I found from records that we didn't. However, your lordship can record my verbal submission. An earlier arbitration proceeding had been initiated, but that was unilateral. They did not participate in that, hence we didn't proceed with it. However, thereafter we gave a proper section 21 notice, which they have received, not replied, and hence, my lord, this action before your lordship. But after your lordship was pleased to pass this order on 19th April, we called upon them to, my lord, negotiate. And we had also forwarded them a link for virtual participation because they have not been, my lord, this is the notice, my lord, which we
so
have.
you'll have to file a supplementary affidavit annexing these
Then, my lord, I shall.
30 days have elapsed I'll keep it after 30 days so the 30 days was probably that
My lord, this is we had called upon them for negotiation on 25th of April.
the time given in the agreement was probably 30 days or
Yes,
something.
yes, yes.
Please show me that clause
My lord, clause 13 of the.
page
Yes. Well, that is page 18 of the application.
yes amicable negotiations within 30 days
Yes.
so when did you give this notice
My lord, we had called upon them for negotiation on 25th. So, your lordship will, my lord, keep this anytime.
Immediately upon reopening.
Yes.
yes supplementary
Immediately upon reopening, my lord, by that time we will file a supplementary affidavit.
reopening after the summer vacation
Yes,
Yes,
because
right,
30
right.
days, my lord, is within the vacation.
please keep take this back
Yes.
learned counsel for the petitioner submits that during pendency of the present application, since a question about the prior procedure of amicable negotiations having exhausted arose, for abundant caution, the petitioner has given an offer by email to the respondent for amicably resolving the issue. Full stop. Next para. The petitioner is directed to file a supplementary affidavit on the next returnable date, indicating such offer and the outcome thereof. Full stop. In order to enable learned counsel for the petitioner to leave a period of 30 days for the purpose of amicable negotiations as contemplated in clause 13.2 of the concerned agreement, comma, the application is adjourned and shall next be listed in the monthly list of June 2023.
Deeply.
Please take that back and just use it
Yes,
in
my lord, I
the.
have.
Thank you.
Item number 3, Chandan Chatterjee and others.
Three lordship, Mr. Sinha said, my lord,
Friday.
Friday.
You are for the petitioner.
Yes, I am for the
My lord, I
petitioner.
appear for the respondent.
On the prayer of the respondent, the matter is adjourned till April 28th, 2023.
And the service on the respondent number 3 is already complete. My lord, we'll file the affidavit of service when your lordship takes up the matter next on
Yes,
Friday.
I'll take up lock, stock, barrel, and
Grateful.
Grateful, my lord.
you also go through the judgment.
Yes.
I haven't seen the text of the judgment. I just saw the reporting on the.
Yes,
live
on
law
live
bar
law,
and
even
bench.
I saw that yesterday. But to be very honest to your lordship, my lord, the issue is if the document requires to be stamped mandatorily, arbitration agreement contained in the document will be non-est and hence the petition will not be maintainable. First, my lord, my learned friend has to demonstrate that the document which contains the arbitration clause is required to be mandatorily
If
stamped.
that is debatable,
Yes.
arguable, then we have to relegate
Yes.
whether it is sufficiently stamped or not.
Yes.
Yes, I get your point. I mean, that's the only point.
Here it's only for transfer of management. There is no transfer of any immovable
Probably we'll have
property.
to go. I'll have to go through the judgment actually. Whether it's during the arbitral proceedings, before using that document, you have to stamp it, have it stamped. I mean, there's a difference between section 11.6a and.
Yes, yes, yes.
All of us know that. Let us see what discussion has been.
Yes, because we have to see the intercontinental hotels also, which had said that if it's inappropriateness or insufficiency, then
Right.
it can go before. But if it's completely non-stamped,
Exactly.
then the petition will
We
not
have
be.
to see how intercontinental has been dealt with by this judge.
Yes, not. I'll just take a printout and read the.
Yes, I'll also have to do
It's
that.
300 pages judgment.
No, 147.
No. 3 judges have affirmed the SMST view, and the 2 judges have, my lord, held the NN Global view.
Very well, let us see.
Grateful.
Grateful, my lord.
If that is arguable, then also it's an arguable matter.
Yes.
Anyway, let us see.
Item number 4,
Yes.
Surya Polytechs Private Limited.
My lord, praying for not this week, my lord.
Why?
My lord, I led by the Devraj Sahu, my lord, and he's
You're
not
for the petitioner or respondent?
for petitioner, my lord.
What is you're objecting?
My lord, due to his personal.
Nobody is there for the
difficulties,
petitioner. You are praying for time till for the day,
Not this week, my lord.
not this week.
My lord.
Very well. On the prayer of the petitioner, the matter is
Appearance to-
adjourned
Appearance to the.
and shall next be listed in the monthly list of May 2023.
Court application under Article 226, item number 5, Sunrit Dev versus CSC Limited Service.
But I appear on behalf of CS.
Right.
My lord, this is the case
Yes, Saldar.
where the same writ petition has been challenged by another writ petition without preferring an appeal for modification or recalling, nothing has been done. Same writ petition was filed in the original site. So
For
it's
the private respondent.
I am for the earlier writ petition.
The name Mr. Haldar is for the petitioner.
No.
My lord, I am
Therefore-
for the petitioner. Your lordship has considered this issue.
Yes.
Your lordship has passed an order on 4th April 2023. Your lordship had directed the CSC to conduct an inspection. There were 2 issues where the petitioner
Please give him the microphone, Mr. Haldar. Taking unilateral
there were
control. of-
2 questions.
Yes.
One is whether the 2 premises where the petitioner and the private respondent resides respectively are structurally the same building on, or it is possible to install a separate electricity meter for giving electricity connection to the present private respondent. This is what was referred. Your lordship, CSC has filed a report yesterday. Now we are taking an exception to the report. Kindly takes the report.
Report কোথায়? Report কি দিয়েছে? দিন না। Thank you. You have taken an exception.
But I'll take, because it was served yesterday. I have not taken a written exception. I'll show
I'll-
the issues
I'll-
in the report.
First,
Your
let me
Lordship.
hear the CSC on this, the
Yes,
tenor of this report,
yes.
I'll come back to it. Yes, Mr. Mukherjee, what is the CSC report?
Minor, we kindly come to the report, minor. Minor, the 9C is the premises is question.
তো অন্য
9C
জিনিস বাবু।
Braden Street.
এটা অন্য জিনিস। এটা একটা সার্কুলার। এটা? এইটা হ্যাঁ। ওটাও থাক, ওটাও থাক। হ্যাঁ। Yes, yes, Mr. Mukherjee.
9C is the premises in question pursuant to your lordship's order, minor. We have given
Take the
connection.
mic, Mr. Mukherjee.
9C Braden Street is the premises in question, minor. Minor, kindly come to paragraph 3, 2 and 3. It was also revealed that each of the aforementioned holding numbers 9A, 9B and 9C have separate service connection. A sketch map is enclosed herewith and marked as Annexure B. While we found that the private respondent establishment being a shop cum residence is part of holding number 9C, and the said establishment of the private respondent also shares a common wall with 9C. In course of the inspection, it was also established by the documents that the private respondent is the tenant of the petitioner. Hence, for obvious reasons, the meter of the private respondent had been installed at the existing meter board service position of holding number 9C, being under the occupation of the petitioner. While it is also pertinent to mention that a meter standing in the name of the petitioner is also installed at the same service position of 9C. May I kindly see the photograph which we have given? This is 9A, 9B and 9C. And paragraph 1 where we have categorically stated that the pink colored painting is for 9C, yellow is for 9B and chrome yellow is for 9A. This is not a structurally separated building. This cannot be.
What is your difficulty, Mr. Haldar, if it is given, I mean, it
No, we
can
have
be given
already-
from the same service position?
Yes.
So what are you opposing?
But they have, the petitioner has appeared before your lordship when the matter was taken up in the appellate side. In presence of the petitioner, my lord, as the private respondent, my lord directed us to give the collection to Mr. Haldar's client at the existing meter board position. We have given that.
They are the landlords.
They are the landlord, my lord, the petitioner. Now they are coming and saying that due to some misunderstanding, nothing was stated when the.
Where is that order? You have annexed that order?
That is at page 30, I think.
Page 30, annexure P2.
কোথায় গেল রে?
In fact, they can prefer an
রিট পিটিশনটাই জানি আমি।
again in the repetition.
You are the tenant.
আমাকে একটা কপি দেবো। আপনারা যেতে পারছেন।
এগুলো ফাইলটা এসেছিল না? Oh, they did not have any objection.
Yes.
They are already enjoying a service connection there, Mr. Mukherjee. The
Yes, yes,
landlord.
yes, it is in respect of 9C there. The petitioner is also there.
I'll come to.
Petitioner is
So-
enjoying.
We are only concerned with 9C for the time being.
Yes,
In 9C, there is a separate service connection,
yes,
just as in A and B.
yes. Manoj, kindly see paragraph 1.
Yes, you have stated that, but that service connection goes to his,
Yes,
he has a connection there.
yes, and the
Now,
tenant
this person tenant has got another connection
pursuant to your lordship's order.
from the existing service.
Yes,
connection. What are you praying now?
Your lordship, I'll just.
So what is your prayer in the writ petition?
My prayer is this, your lordship in that last order had said, my lord, I quote the relevant part, that if the CSC were to hold an inspection at the premises in question for the purpose of ascertaining feasibility of giving a new electricity connection to the petitioner there. It was further observed that if it is found feasible, such connection was to be given to the present private respondent within a fortnight from the compliance of all formalities at the existing meter board position. Now kindly takes the inspection report which is given. There is a diagram. Kindly takes it. So my lord, 9A, 9B, 9C were structurally one building. I am carrying the partition deed by which this building was
Did not
partitioned.
raise any objection on the last occasion.
Yes, your lordship, kindly sees the order dated 20th April
কি বলছেন?
4th April 2023. Your lordship has noted my
No,
objection.
no, on the previous occasion, when the previous writ petition was moved,
Yes, writ
it was
petition.
passed in your
Your
presence.
lordship, I was not aware. Kindly consider this.
You were not aware means your client
I
was
am-
not there.
No,
He was represented.
My lord, kindly 1 minute. My premises has a common passage leading from Bidan Street. His premises is structurally separate. I'll show that. And his premises, he's my tenant.
Cannot reopen
But
that order.
He is having
Specific
the
order was passed in your presence.
My lord, to consider the feasibility.
And impose
he
costs
can
on
be
your
given-
client for harassing them unnecessarily.
Kindly consider this. Kindly consider 1 moment. It will not take your lordship. Kindly take their diagram, which they have given.
Yes.
My lord will see my meter box is at this end from Bidan Street in the passage in their inspection report.
Shiv Chandra Bhomik is
He is the tenant, private respondent. His opening is from CR Avenue or at the behind my premises. So my meter is here, my lord, at the entrance of 9C. So if he is given meter box from here, my building has to be disturbed and the electricity line has to be taken through my building to give him. I
can
am
be
saying
taken over the
simply-
side wall,
Your lordship, now
clamps which can be set in
I'll
place.
tell your lordship, the site
Yes.
is a premises 326A Chittaranjan Avenue. His premises is having one common wall with me, one common wall with the boundary wall of that premises. On that boundary wall, they have a meter box. 326 Chittaranjan Avenue. Your lordship, these premises were not structurally part of my building at the time of partition of.
So why
5
did you
and
not
9
object specifically?
Yes.
Your lordship, because your lordship at that time it was only, I had only consented, he is entitled to electricity. I am not denying that. I have consented that he is entitled to electricity. All I am asking is let the CSC provide him his own meter box. Why my meter box will be used and entire line will be
That
drawn?
is technically not feasible. CSC is saying, what can we
My
do?
lord, that they
They are
have
the
not
technical
considered.
people,
Your
not you
lordship
or me.
takes the report. They are saying obvious reasons this is technically feasible. They are not saying why from CR Avenue he cannot be
He
given his
resides
own.
in one premises, take connection from another premises. What are you
No,
saying?
not from the other premises. He can have his own meter box in his premises. He is facing the street.
CSC
From
is
the
saying
street,
no. How are you saying yes?
I-
Are you a technical person? What is your qualification? Your clients?
My lord, let me file a technical report then from my.
What is your
qualified person.
client's qualification?
He is an advocate. His son is an electrical engineer. My lord, let me place my, because my
Son's
lord,
report won't do, sir.
my lord, kindly consider the order which was passed after considering these facts. Your lordship had asked them to see whether the building is structurally same. He is only enjoying
They
one
say
common
it's same structurally.
They have not said in the report. Now it is submitted. They are saying there is only one common wall. In North Kolkata, your lordship, all premises are having common wall. There is no space between buildings.
Therefore, in North Kolkata, nobody else will
No,
be
I'm-
taking electricity connection.
Your lordship, let him get his own meter box. Every time he has to repair his electric line, he will enter my premises.
Right.
He has been given
Not he.
completely.
But the CSC people will, definitely will.
My lord, no.
Your
my lord,
meter
they
can
will
be-
give the
If
meter.
your meter can be repaired, his meter can also be repaired.
Well,
He's a
from
tenant
meter,
there, no?
He has to draw line to his premises.
No. Premises are the same, 9C.
My lord, kindly consider.
You are the owner of 9C, they are the
Kindly
tenant of
consider,
9C.
if this was one building, there were flats in between, one common entrance, meter is put in the common entrance. He has entrance from CR Avenue at the other end.
Maybe.
I am having entrance from Bidan Street. My meter is on the Bidan Street entrance, my common passage. And this is my lord private passage, not a public
Mr.
road.
Mukherjee, why cannot CR Avenue side be given a meter?
My lord, he is a
Because the
tenant.
one service connection is already there.
My lord, kindly see paragraph 3, what we have stated in the report. The private restaurant yesterday being a shop cum residence is a part of holding number 9C. Now, we cannot deviate from this, my lord.
But there is no rule that a
The
separate meter
application
box can-
obviously has been in respect of 9C.
Heard learned counsel for the parties. First up, the petitioner is a landlord of the premises in question, comma being 9C Bidden Street,
9C Bidan Street.
Bidden Street, comma Kolkata. First up, the private respondents, comma on the other hand, comma being the tenants in respect of the same premises, comma had taken out a writ petition previously bearing WPA number 5115 of 2023, comma, which was decided with the order dated March 16, 2023, comma, in the presence of the present petitioner stroke landlord, comma, who was the respondent number 4 therein. Next para. In the operative portion of such order, comma, the CSC Limited was directed to hold an inspection at the premises in question for the purpose of ascertaining feasibility of giving a new electricity connection to the petitioner therein within bracket present private respondent stroke tenant bracket closed within a week from that date full stop upon such inspection comma if it was found feasible comma such connection was to be given to the petitioner therein within bracket tenant bracket closed within a fortnight from the compliance of all formalities by the petitioner at the existing meter board position. Full stop next para. It is seen from the preceding paragraphs that the court also went on to record that the present petitioner, comma, who was the private respondent number 4 therein, comma, within double inverted, does not otherwise have any objection to the electricity connection being given to the petitioner if the petitioner is so entitled otherwise in law, double inverted close. Full stop. Next para. It is seen from the further previous paragraphs of the same order that learned counsel appearing for the private respondent number 4 therein within bracket present petitioner bracket closed submitted on instruction that no prior notice was given at any point of time to him at the juncture when the inspection was sought to be taken by the CSC personnel. Full stop. As such, comma, the said private respondent number 4 was well within his right to refuse the entry of the CSC personnel. Full stop. Next para. It was also recorded that in view of misunderstanding, comma, the private respondent number 4 therein had objected to the inspection being held. Full stop. Next para. A composite reading of the said findings in the said order, comma, passed in presence of the present petitioner, comma, clearly goes on to indicate that the objection of the present petitioner stroke landlord was only on the premise that no prior notice of inspection was given to him. Full stop. Next para. It was also recorded that there was a misunderstanding for which the present petitioner had objected to the inspection being held, but otherwise had no objection to the electricity connection being given to the petitioner. Full stop. Next para. It is obvious, comma, by common sense as well as evident from the report filed by the CSC Limited that since there is already an existing service connection at premises number 9C, comma, which is structurally the same as premises number 9B and 9C, comma, all of which share a common wall, comma, it is not feasible for another service connection to be given to the petitioner. Full stop. Next para. Unless a second service connection is given to the same premises, comma, it is technically not possible according to the CSC Limited to install another separate meter for the petitioner, for the private respondent stroke tenant, comma, unless the connectivity is given from the existing meter board position. Full stop. Next para. Hence, comma, there cannot be any further scope of the present petitioner stroke landlord now coming up and resigning from his previous position, comma, which is evident from the order of the court passed in WPA number 5115 of 2023, and now argue that the petitioner ought to be, and now argue that the private respondent stroke tenant ought to be given service connection from the other end of the premises by installing a different meter there. Full stop. Next para. The limited scope of the inspection directed by the previous order was to ascertain the feasibility of giving a new electricity connection to the petitioner. Full stop. Next para. Since the CSC Limited has specifically reported that it is so feasible, comma, but from the existing meter board position at the premises, comma, the right of the tenant stroke private respondent to get an electricity connection at the premises where he resides cannot be curtailed by a post facto harassive attempt by the landlord. Full stop, next para. In fact, comma, it is clear from the above discussions that the conduct of the malafide in now coming up with the afterthought of filing the present writ petition and resulting from the specific undertaking given in court, comma, is patently malafide and harassive. Full stop. Accordingly, WPO 747 of 2023 is dismissed on contest. Full stop. The petitioner shall pay costs of rupees 20,000 to the private respondent within a fortnight from date. Full stop. Urgent certified copies.
One thing, 9A, 9B and 9C have separate meter boards. That your lordship has said.
Yes, please call on the next.
And your lordship,
Password is-
special equities for the tenant.
শেষ হয়ে গেছে?
Your lordship,
Call on that
special equities will be claimed by the tenant.
No, this time equities will be created, sir.
Your lordship, may I be permitted to file my reports?
You had filed a report on the previous occasion, Miss. Again, report why?
No, this is on behalf.
This is on another, that is a, very well. The report filed by the state be kept on record at a line. Appellate side.
My lord, may I have a leave to mention?
Appellate side?
Yes.
Let my officer come first. He's not as fast as you, Mr. Shamil.
No, my
আচ্ছা দাও লিস্টটা কি করছো? চিন্তা ভাবনা করছো কেন? দেখে তো মেনশনিং হচ্ছে, বলো এনি মেনশনিং অ্যাপেল সাইড।
lord, yesterday your lordship passed the judgment, my lord. There is a 3 typographical error.
To be mentioned tomorrow.
Tomorrow, lordship.
Call on the list. আচ্ছা শোনো অরিত্র, 9 পর্যন্ত পাস ওভার ইন দ্য ফার্স্ট কল, 9 এর পর আবার সেকেন্ড কল নেবে, কল করো।
Appellate side. New motion item number 1.
Well, I am very sorry that I am without morning gown. Please,
Without?
morning.
We even, I got time, barely got time. When I got the notice, I barely got time. That's why I was 2 minutes late actually.
When I get down, enter into the court, then
No difficulty, no difficulty.
Please excuse me.
No, you're excused, but you won't be finding any morning man now.
No,
There's a crisis now probably.
Do you are also, do you are.
Huge number of
Now there will be crisis immediately after the notice is given. You can crumple your band and wear it in the second. Yes, Mr. Rohan, what is your case?
My case, this is regarding, lordship, kindly remember, on last occasion.
Compensation, WBSETCL is.
Yes, lordship, kindly turn to page 14 first. This is a notice issued by the BDO.
Yes, right.
Regarding, the subject is construction of 132 kV double circuit from Baripur. So, they wanted to, the high voltage connection through my land. I am ready to, give the land, but with proper compensation.
Very well, Mr. Rahman, I'll direct them to pay compensation upon assessment on hearing you. And if there is any dispute, you have the liberty under section 16 of the Telegraph Act to go before the district judge. I'll keep that, make that clear. So I'll pass my order. Yes, Mr. Panjay, any difficult? Right. WPA 7451 of 2023, comma, the present writ petition, comma, has arisen from the prayer of the writ petitioners, comma, allegedly the owner of a land over which a high tension electricity connection is sought to be taken by the WBSETCL. Full stop. Next para. Learned counsel for the WBSETCL submits that the said connection is being sought to be taken for public utility purposes and shall serve several people in the neighborhood and elsewhere. Full stop. Next para. Upon hearing learned counsel for the parties, comma, it is seen that the scope of the present writ petition is very limited inasmuch as the WBSETCL, comma, the licensee, has the power under section 10 of the Indian Telegraph Act 1885, comma, read with section 185 of the electricity.
165.
Acha, read with section, read with the
164.
64. no?
read with section 164 of the Electricity Act 2003 to lay cables and lines over any property, comma, subject, comma, of course, comma, to payment of compensation. For sub next para, under section 16 of the same act, comma, if a dispute arises regarding the quantum of compensation, comma, it will be open to the parties to move the concerned district judge for resolution of such dispute. Full stop. Next para. In such view of the matter, comma, WPA 7451 of 2023 is disposed of by directing the WBSETCL, comma, upon completion of the work, comma, within a month thereafter, to give an opportunity of hearing to the petitioner and other affected parties, and thereafter to assess compensation payable to the petitioner, if any, in accordance with law. First up, it is expected that such compensation will be disbursed at the earliest thereafter. Full stop. Next para. In the event the petitioner has any grievance regarding the quantum of assessment made, or in view of the main order of assessment, comma, it will be open to the petitioner to approach the concerned district judge having territorial jurisdiction with such dispute. Full stop. If so approached, comma, the same will be decided in accordance with law. Full stop. No orders to cause urgent certificate. Right. You are added as a he was added as a party.
Respondent number 2. My lord, corrected because there was a typographical mistake, my lord.
Achha.
That has been corrected, my lord, on the first occasion.
That has now been
Respondent
corrected.
Yes,
Very
yes.
good. That's all.
Respondent number 2 here. Developed.
Item 2.
Yes, Mr. Mukherjee.
Earlier directed to CSC authority to inspect, and they inspect and also kindly see.
Use a microphone, Mr. Mukherjee.
They inspect and submit a report. I accept the report today. But as per Annex A, they
Mr. Ghosh is for the private respondent.
only point
To give report in advance. Just now.
My lord, advance I put not.
It will come back tomorrow. Do you have any objection to the report?
No. The objection.
Mr. Ghosh may have, because he is not having, the other side may have.
May I file it?
What does the report say?
My lord,
They did not file any application as such CSC.
my lord, we have given the dispute is in respect of, there was a deed of conveyance, and in the respect of deed of conveyance, clause 2.1, the properties has been divided in lot A.
That's a seeking connection here.
No. Lot A and Lot B.
Yes.
Lot A is in 319A and Lot B is 319B. Manad, according to the that deed of conveyance, Manad, they have to apply and they have to shift the meter of the parties who are taken the
There was a partition.
On the basis
on
of
partition. Manad, but they have not applied to CSE. Minor directed us to inspect. We could not go and inspect. Minor directed us to inspect and see whether a new service can be given. When we have inspected, Minor, kindly see paragraph 7 of the report and the sketch map we have given. When we have found out a suitable location at the
That is within his premises, Mr. Mukherjee.
yes, 319A. When kindly see the annexure A, that is the sketch map which we have given.
And the 319 by B is Mr. Ghosh's client.
No, 300B, 19B is my petitioner's premises. 300.
The petitioners want
A
Mr. Ghosh's client. If my lord kindly peruse your lordship's order dated 10th of April.
Where is that position?
That
Also
is-
last page, the report, or proposed position already all there.
My lord, this is position.
As a proposed service position.
Huh.
That will be on the common passage, but outside 319 by A.
Yes, and they have got two separate.
Mr. Mukherjee is in B.
Yes.
B.
They have got two separate entries for both the building.
But there was another common meter room here.
Well, that is already there, enjoying the clause in the partition deed that it will automatically shift upon making application.
No.
Kindly peruse your lordship's order dated 10th of April 2023.
Acha. Their meter, Mr. Ghosh's meter will be shifted.
Yes.
Yes, Mr. Ghosh, let it be shifted.
Well, they have to make application for new service connection and for shifting. That
Who will have to make? They will have to.
They file an application and in terms of the partition deed, I will bear the expenditure. Regarding shifting
Mr.
expenses.
Ghosh, is your client present? Somebody present? Will you take instruction on this? I'll record this order, just take instruction, come back tomorrow, say yes, I'll pass my order. If you say no, then I'll hear it. Learned counsel for the CSC Limited files a report. First up, it is indicated therein that upon an inspection, the CSC personnel have been able to locate a feasible spot for shifting of the electricity meter of the private respondent, who has been allotted holding number 319/A, Chaudhuri Bagan, Kolkata 7,48,000, which will be adjacent to the premises of the private respondent. Full stop. Next para. Since, as per the partition deed, the petitioner sought for such shifting, the expenses of which will be borne by the petitioner, there cannot otherwise be any impediment to the said shifting. Full stop. However, since a copy of the report has been served on the learned advocate appearing for the private respondent here and now, to enable learned counsel to take instructions from their clients, the matter is adjourned till tomorrow. Full stop. The learned advocate for the respondent shall apprise the court as to his instructions for the passing of further orders.
I'm getting.
You have got a copy. You can have a talk with your client and just see whether if it's possible. They will bear the expenses. That will make clear in the order because they are agreeing.
No, that is there in the terms.
That is there in the terms and they're agreeing. No dispute on that.
I'm getting.
Unless subsequently, Mr. Ghosh, there is some family dispute between you.
Family dispute is there.
It will always be there. But please agree then.
Because the third party has purchased the brother's share. That is the term.
Let it be resolved if possible.
Item 3.
My lord, I am for the petitioner, my lord.
Yes.
After receiving the petition, my lord, they
State.
have given connection to the private to the petitioner, my lord.
So infractuous now.
My lord, infractuous.
You are appearing for the?
For the state, my lord.
Very well. It is submitted by learned counsel for the petitioner that subsequent to the filing of the writ petition, the connection sought by the petitioner has been given by the WBACD Full stop. Next para. Hence, the cause of action of the present writ petition has been rendered infructuous. Full stop. Accordingly, WPA number 8700 of 2023 is disposed of as infructuous. Full stop. No orders to cost. Onar namtao record. Please give it.
Obliged.
Item 4.
But I appear for the petition.
My lord, Mr. Naik is for the WBSCDCL. Is it from courtroom number 1, my lord?
Pass over in the first call.
Pass
After 9, I'll be taking up these matters.
My lord, kindly fix that.
No. You'll
My
be there. No, you'll argue on that day.
No, my lord, I have no instruction. That's why, my lord.
Take instruction in the meantime. You'll get 5 minutes.
My lord,
Take
kindly
instructions.
come
No.
to my lord.
You're sufficiently competent now.
Yes, my lord, I know that. But
Take
my lord-
instruction, come back. Yes. First call.
Item 5.
Yes,
my lord, he is coming.
Yes.
Yes,
I knew he would be coming. He's very sincere, diligent. So on the second call, I'll be taking it. Yes.
Second call.
My lord, make it not to lordship.
No. Second call.
We regard to item of 5 minutes.
No, I have the decision.
Tomorrow. Yes, Mr. Rai, you have been managed. Regarding time, regarding adjournment only, nothing else. Obviously.
I know.
Very well. On the prayer, you are for the petitioner, Mr. Banerjee? On the prayer of the petitioner, the matter is adjourned for the day.
Item 6.
I am for CSC.
Yes, Mr. Chatterjee, you are for the petition?
I am for the respondent number 3,
Who is for the petitioner? Yes.
Your Lordship, we are appearing on behalf of the petitioner.
Who your matter?
Yes. We are also filing a fresh affidavit of service for the same.
All have been served. They're appearing also. Mr. Chatterjee is there for the purpose. Very. Yes, what is the matter?
Your
Mr.
Lordship,
Chatterjee, please take your seat. And Mr. Dr. Shahara,
Yes,
please take your seat.
Your Lordship, may I proceed?
Please.
Your Lordship,
Don't try to sit now. Yes, after you finish.
Your Lordship, the given writ petition has been filed under Article 226 in violation of Article 21, freedom of personal life and liberty enshrined under the Constitution,
And section 43.
and Section 43.
Yes.
Your Lordship, if you may proceed, I'll just give you a brief state of the facts which has happened in the case.
How long are you practicing?
Your Lordship, it's been 1.5 years.
1.5. Very. Please the facts.
Your Lordship, it's a pretty interesting case here. On the petitioner hearing is a welfare society, Moon House Welfare Society. So on the 16th of October 2020, Your Lordship, a fire had broke out in the said premises bearing 21 Ganesh Chandra Avenue. Your Lordship, post the fire, the CSC had come in and had disconnected the electricity supply, stating that that was prerequisite in order to cut down the fire. So after a considerable period of time, all the tenants herein, they're all bona fide tenants, Your Lordship. So everyone started writing invoices, notices in the form of correspondence to CSC. A considerable point of time had passed. After that, Your Lordship, there has been no reply from the CSC. Finally, Your Lordship, on the
Mr. Chatterjee, you are for the custodian.
I am for the respondent number 3,
Custodian.
Custodian, Lordship.
Well, please take it. Yes, please continue. What happened then?
Yes, CSC had finally replied to the said notices which had been sent by the tenants, and they had stated specifically, like, there are certain requisites which needs to be complied by the tenants.
Show me the page.
Yes.
150 onwards.
You are Mr. What is your name, please?
Shorjo Ganguly.
Mr. Ganguly, please place the relevant page
Yes.
of their notice.
Your Lordship, annexure P6,
Page.
page 146 to 171 deals with the notices which has been sent by CSC.
Why so many?
Because it has been sent to all the tenants.
What
So
are the requisite?
the requisites were, Your Lordship, the first being no objection certificate, which has to be issued by the Lal Bazar Fire Department, and the other being the test certificate, which was received from the West Bengal government-based electrician. So we were duly told to comply with the same. A delay of around 1 year, 1.5 years. So all the petitioners herein were actually happy in the sense that at least there has been a reply from the said CSC authorities, and they had duly complied with all the requisites, Your Lordship. After complying with the requisites, to the dismay of my clients, what has happened is CSC has come up with another notice, Your Lordship. Your Lordship, the notice being.
You should take your notes on the left-hand side margin of your
Yes.
copy, so that it's handy for you.
Yes.
You can easily refer.
Yes, Your Lordship.
You can read with these page numbers at least. Yes.
Yes.
Page?
Page 146, Your Lordship. Notice sent to CSC. Yes, page 146, annexure P6, page 146.
(146) is a subsequent notice. You annex the subsequent notice before the prior notice. Same date, not 146 probably.
Your Lordship, this is a bunch of the notices actually.
You said subsequently there was another set of notices.
Yes, Lordship.
What is the ultimate position? Tell me your grievance now.
Yes, the ultimate position is, your lordship.
Hmm.
Actually, your lordship, the custodian has come into the angle of this particular case.
It's an enemy property.
It is an enemy property, your lordship. Also, your lordship, I would like to peruse to an order which was
So what
passed.
is your grievance? Tell me. What is
The
the problem?
grievance is like, it's been more than 2 years. All of them are like bona fide tenants as per the rent receipts, and all the due bills have been cleared with the CSC. But till date, despite fulfilling all the requisites which was passed by the CSC authorities, we have not received the electricity connection.
The custodian is not in possession of the matter.
Your lordship,
Is the custodian in possession of the matter? They gave a notice to you.
yes, your lordship, via the CSC, not directly. Via the CSC, we have sent a notice.
So now you're not getting back your restoration of electricity.
Electricity
That
supply.
is your
Yes,
topic.
that is the grievance. Our prayer is very simple. It's only with regards to
So
the
you have obtained these
disconnection.
things. These whatever license.
Yes, your lordship.
All these are
All
you
the
have annexed here.
all the requisites have been annexed. I'll just
Get ready on the page numbers. In the meantime, I'll hear Mr. Chatterjee on what is the objection of the.
Grateful.
Yes, Mr. Chatterjee. Give him space, please. Now don't sit immediately. There's no chair behind you, Mr. Ganguly. Yes.
Lord, I'm for the respondent number.
Yes, Mr. Chatterjee, what is the objection of the custodian?
Lord, as a matter of fact, there are Lord.
Mr. Chatterjee, please take the microphone.
I'm sorry. I'm extremely
Yes,
sorry.
yes.
So as a matter of fact, Lordship finds that there are 39 petitioners. The property belongs to the respondent number 3. Out of 39 petitioners, Lord, 35? 36 petitioners, Lord, were found to be in illegal. 35 petitions were found to be in illegal possession. Lord, I have exercised my right, Lord, under PP Act 1971, Lord, and the state officer has given notice. By the reasons of such notice, Lord, the eviction order has been passed. And the eviction order has been challenged under the Act, not before the City Civil Court. Appeals are pending. So, Lord, so far 39 petitioners are concerned, 35 are not a tenant now. So far, the balance 4 are concerned, they have just a second. So for the balance for 4 or 3 are concerned, they have applied before the authority that they want to continue on payment of rent, and their requests have been accepted. On that basis of acceptance, Lord, provided to them, Lord, the acceptance was communicated to the CSC that yes. So for these 3 or 4 persons, occupants are concerned.
Mr. Chatterjee, would it be possible to file an affidavit in opposition, just indicating the names of those people who are now not in possession?
No difficulty at all.
Can it be done within a short period, because this is electricity matter? How short? How can you do it? Just take instruction, Mr. Chatterjee. Take your instruction.
Just a second.
He's wanting 1 week. I'll give you 2 weeks. I'll give you 2 weeks. He's wanting 1 week, but I'll give you 2 weeks because to draft you will have to. I'll give them 2 weeks time. They'll file an opposition. 1 week for you to file a reply, and upon perusing those documents, if some of these tenants are in illegal occupation, according to the custodian, we cannot probably direct this. I mean, the tenants association generally we cannot. So there will be some modality called out from that. Let us see.
Lordship, if I may.
For the time being, I'll only direct affidavits to be filed. They'll file affidavits in 2 weeks. You'll file in 1 week. I'll take up after 3 weeks. For final hearing.
Grateful.
The petitioner's grievance.
But CSC doesn't have to give any affidavit on that subject.
I'll direct all the parties, but if you don't want, don't. You may have a stand on this also.
This is a stand of the respondent.
If you say you don't want to use, I'll record.
No, don't record. Kindly don't.
That's why I'm telling. I'll have to give. We don't have any direct. State will definitely have to file a.
I'm not may I submit one thing.
Yes.
Not so far the reliefs are concerned, these are all directed against the defendant number 1, respondent number 1. So far the grounds are concerned are all directed against the respondent number 1. And in the entire petition, Lordship will not find one single line so far the respondent number 3 is concerned.
So no cause of action disclosed.
Kindly see. I at least didn't find.
You are led by somebody in this matter, or you are the counsel?
No, your lordship.
You are the counsel. I'll give him supplementary affidavit permission.
Supplementary affidavit.
Your lordship, also because we are not actually involved with
What is
the
the
role.
cause of action against the custodian? Why are the parties here? Show me from your writ petition.
So, your lordship,
Maybe because of the reason, Lord, if your lordship would kindly permit me to interrupt my learned friend,
Yes.
kindly come to Lord page 192.
This interruption will be helpful for him. Page 92.
192, Lord.
192, I'm sorry.
Lord, and this is their demand upon the parties here before Lordship, Lord, and kindly turn to page, Lord, 194, or rather 193 bottom, last line. However, despite the same, as on 8th of March 2023, CSE through its DCM Central informed my client to contact the custodian of the enemy property, referring to the letter dated 20th February 2023, wherein it was stated that they require clearance in writing from the office of the custodian of enemy property. Maybe that is the reason why I have been brought in, but nothing pleaded. But
Pile up, yes, you have to plead something on that. You will be cautious the second time.
Lordship, that is the sole ground. Actually,
And
we had filed it against CSE, but
So
we
if the
thought it
custodian
is.
says, then we'll have to accept on face value unless you rebut that by cogent evidence. You can rebut whatever they
so
say.
far the respondent number 3 is concerned, my Lordship would see, he has been made a party by name. Not he has been transferred. The present.
Oh, delete the name. Why keep the name?
Yes.
Is it mandatory? I don't think
No,
so.
not at all. Not at all.
The office has to be done.
Yes, that's right.
Acha, it is pointed out by the learned senior advocate appearing for the custodian of enemy property, being respondent number 3, that the person named as the custodian in the writ petition has since been transferred. Mr. Chatterjee, do you know, transferred or demoted office?
Transferred.
Since been transferred somewhere else. Full-stop.
Present incumbent, Mr.
Need not.
No, not necessary.
Not
necessary at all.
Full-stop.
His office has been made.
In any event, it is seen that the custodian of enemy property for India has been impleaded in the present writ petition in the capacity of such office, and as such, no incumbent at such post need be mentioned specifically. Full stop. Hence, the learned advocate on record for the petitioner is granted leave to delete the name of the respondent number 3, retaining the office of the same. Full stop. Next para. At the outset, it is further argued on behalf of the respondent number 3 that no specific cause of action is disclosed in the writ petition against the custodian of enemy property for India. Full stop. However, the learned senior advocate appearing for the respondent number 3, in his usual fairness, indicates that a document dated March 14, 2023 has been annexed to the writ petition, which shows that the petitioner was referred by the distribution licensee to take clearance in writing from the office of the custodian, which might be a reason for the impleadment. Full stop. Next para. Be that as it may, since the respondent number 3 is justified in arguing that no specific cause of action has been made out in the pleadings,
and no relief, no relief also.
Nor any reliefs have been sought against the said respondent, leave is granted to the petitioner to file a supplemented affidavit on the next returnable date, with advance copies to the learned advocates on record for the other parties, disclosing the specific cause of action and the relief sought against the respondent number 3. Full stop. Next para. On merits, it has been indicated by the learned senior advocate appearing for the respondent number 3 that the property is in possession of the respondent number 3, the custodian of enemy property, and out of the 39 tenants, who are purportedly represented by the petitioner association, about 35 have already suffered an order of eviction under the Public Premises Eviction of Unauthorized Occupants Act 1971, against which appeals are pending under Section 9 of the said Act. Full stop. Next para. Insofar as the rest of the tenants are concerned, upon due application, there is no apparent impediment to give electricity connection in their favor. Full stop. However, since arguments on facts have been advanced, the respondents are directed to file their affidavit within bracket S in opposition within a fortnight from date. Stop. Reply, if any, shall be filed within a week thereafter. The matter shall be listed for hearing on May, on June, on the reopening date after the oncoming summer vacation. After the upcoming summer vacation, the first day, that will be the expiry of the 3 weeks.
Lord, could it be a week after the vacation? Because I tell you, Lordship, Lord,
No, whatever, yes.
maybe, Lord, I have to.
The 2 weeks, let us see whether it comes before the vacation. I mean, we are today on 26th, Wednesday. I'll keep it on 18th then, 18th May. Before the vacation.
No problem.
Very well.
No
problem. Reopening date na kore, the matter shall next be returnable on May 18, 2023. Thank you.
Grateful.
Please file the supplemented affidavit, give copy to them in the meantime, file it on the next returnable date. Great. Thank you. Give copies to everybody, Mr. Ganguly.
Yes, Lordship.
Call on next one.
Item 7.
Yes, Mr. What is it?
I am for CSC.
Right.
Lord, kindly. Protima.
Private respondent served.
Yes.
I appear for respondent number 5.
Very. Yes. What is the matter, Mr.
Now, Millard, kindly comes to the cause title of the writ petition. Kindly see, Millard, who is the petitioner is Protima Mondol.
Right.
And kindly see, Millard, respondent number 5, 6, and 7, Mamata Das, Probit Das, and Ila Das. They are the Millard tenants. There is no dispute regarding the landlord-tenant relationship. Now, Millard, on inspection, we found that the CSC Limited has given connection in the name of one Bongshi Pandit. Millard, he is not even an occupier of that property. He is not our tenant. He is nowhere.
Bongshi Pandit has not been implicated.
Millard, we do not know what is his whereabouts.
Could have written to the CSC Limited about
Yes, after filing of the writ petition, Millard, letter has been given to us by the CSC.
Is given?
No, kindly see paragraph number 1.
So you know the address now.
I know the address.
Complete server copy. When it will come back without service, then you will see that
This is the same address as us. We know this is nowhere.
Sir, what is it?
I have to implement them.
Complete
Exactly.
server notice, which will come back with whatever endorsement you feel. And after that, you will say that will be the ground for.
Only one thing, Millard, on the next returnable date, late Millard, since Millard, Bongshi Pandit, Millard has applied for a connection, he must have given some document of possession with regard to him. Let CSC produce that before your lordship. Because
first, let me hear this. Yes, Dr. Shah, what do you say?
With deepest respect, I humbly submit your lordship. Kindly come to paragraph 8. Here he has pleaded that she doesn't know Bongshi Pandit. But the thing is, your lordship will be astonished to see that
nowadays I'm not astonished.
No, lordship will find that she was the consumer since 1991.
I'm really astonished.
And this Bongshi Pandit is the consumer since 1992. And this meter is still in live conditions. And what happened, your lordship will find that another person, the relative of Bongshi Pandit, has applied for transfer of the meter. And on that basis, he has paid the requisite fees. And
the relative is one of the private respondents here?
No.
What is your stand in the you are for the Dases? Yes. You say you are the tenants that you are enjoying electricity.
My lord, we are enjoying the
no connection with Bongshi Pandit.
No.
Very well. Yes, then.
Yes, the thing is now the meter is in live conditions, and we are getting the electric payment relating to the electric bill.
Specific objection has been taken.
The objection was they have taken after 30 years. Kindly appreciate the situation.
So what? You are going on giving connection to a non-existent person.
We are non-existent.
You will have to establish, Mr. Dr. Shahara, that they are there. Or what documents he produced, Bongshi Pandit.
We can disconnect on the 3 aspects.
Don't disconnect. First, show us why you are continuing.
Yes. That will.
Yes, you have any nexus with Bongshi Pandit. Then take the microphone. What is your name?
My name is Shayok Konar.
Mr. Konar, what is your submission?
My lord, if there is a dispute, if the meter can be transferred in the name of the tenant, then we can enjoy that. If there is a tenancy, we will pay the requisite fee, everything which is required, my lord. If a tenancy,
very well, I'll direct short affidavits to be filed. In the affidavits, Dr. Share, you disclose, I'll indicate that. You will disclose the whereabouts of this Bongshi Pandit, or at least the documents furnished by him, or whatever is there on your record. And you will, in your opposition, you will indicate this prayer.
Grateful.
Not as a prayer, put it in there. You are willing to whatever.
But there is otherwise no dispute because in landlord and the
Yes,
existing
between
tenants.
you, there is no
No
But
dispute.
we have to ascertain whether Bongshi Pandit, both of you are trying to oust one Bongshi Pandit.
But
So we have to ascertain that
he
first.
is non-existent. He is not there at all.
According to you, your
Yes.
claim.
Yes.
Learned counsel for the petitioner portrays a peculiar predicament before the petitioner. First up, although the petitioner is a landlord of the premises in question and the private respondent numbers 5 to 7 are tenants, comma, it was discovered recently that the CSC Limited has been giving electricity connection at the petitioner's premises in the name of one Bongshi Pandit, comma, who is non-existent according to the petitioner. First up, next para. Hence, comma, it is submitted that the said connection may be disconnected. What is your prayer?
Yes.
May be disconnected. Full stop, next para. Learned counsel appearing for the private respondents tenants submit that they do not have any objection if the meter is transferred to their name, comma, since they are admittedly residing at the premises in the capacity of tenants. Full stop. Learned counsel for the CSC Limited, comma, on instruction, comma, submits that apparently the said Bongshi Pandit has been enjoying electricity connection at the property for about 3 decades, and recently
One Sudarshan
Pandit has applied for transfer of the meter in his name, comma, allegedly in the capacity of a relative of Bongshi Pandit.
And he has deposited the security
Whatever.
deposit.
Full be that as it may, comma, since certain factual circumstances are required to be brought into the picture, comma, as portrayed by the CSC Limited and the private respondents, comma, the respondents are directed to file their affidavits in opposition within 2 weeks from date. Full stop, reply, if any, shall be filed within a week thereafter. The matter shall be listed on May 18, 2023. 18th May. 18th May or after the vacation? After disconnection, after the vacation. You're wanting to disconnect some connection?
But they need 3 weeks. Kindly make it 3 weeks. Affidavit.
Why? No. 2 weeks, 1 week.
But I want to enjoy that part.
No. You won't enjoy anything. Very well. The matter shall next be listed in the monthly combined list of June 2023. That is the reopening date.
Yes.
But instead of reopening date, can
Let it be in the list. If you are in difficulty, Dr. Shara, just point.
as we lost.
Reopening dates are not usually very.
Bad for us. We have to come to court. That's why this is a sort of vengeance against the bar.
Item 8.
Yes, Mr.
I'm from the petition. Lordship,
Yes, Mr. Mukherjee,
petitioner is a co-sharer of a premises
you are the
applied
culprit or messiah in this matter?
for commercial domestic connection. Lordship, primarily applied. The CSC authority did not take any step to give connection. Thereafter again applied. And Lordship, same CSC authority has not given such
Yes,
connection.
Mr. Mukherjee, why?
Splitting up of load. Why, my lord? Because we made the inspection and found that the wife is enjoying the electricity from the common meter of the husband. Now we are yet to issue the order, my lord. That was
Communication.
Communication.
I'll record your communication.
Splitting up load. Kindly. Because admittedly she is enjoying from the
I'll
husband.
record your submission, relegate them to the grievance redressal.
Good submission. Honest submission.
Good submission.
Honest submission.
He thanks you for appreciation. You gave some other reason, Mr. Mukherjee, as usual, like your pleadings.
CSC.
Learned counsel for the petitioner argues that despite having applied for a new electricity connection in his name, comma, the petitioner has not been given such connection by the CSC Limited as yet. Full stop. It is appearing from a communication dated September 30, 2022, annexed to the writ petition, that the CSC Limited informed the petitioner that their site inspection and verification of records revealed that more than one application in favor of the petitioner at the same premises is under process. Full stop. Next para. At the time of argument, comma, learned counsel for the CSC Limited submits that the wife of the petitioner.
No,
No,
petitioner is the wife.
I am the wife.
Oh, I'm sorry. The husband of the petitioner, the spouse of the petitioner is at, because there may be a change soon in the law. So the spouse of the petitioner is already enjoying an electricity connection at the same premises, comma, for which the CSC Limited apprehends splitting of load in the event another connection is given to the petitioner. Full stop. However, comma, it is candidly submitted by learned counsel for the CSC Limited that such communication has not yet been made to the petitioner. Full stop. Next para. Be that as it may, comma, since it is evident from the submission of the CSC Limited, comma, made on instruction, comma, that the CSC Limited has a specific dispute as to the apprehended splitting of load if connection is given in the name of the petitioner, comma, it is the concerned grievance redressal officer who is the competent authority to decide such issue. Full stop. Accordingly, WPA 9497 of 2023 is disposed of by granting liberty to the petitioner to approach the concerned grievance redressal officer with the dispute as raised in the present writ petition. Full stop. Upon such approach being made, comma, the grievance redressal officer shall give an opportunity of hearing to both parties and decide the issue in accordance with law as expeditiously as possible, comma, positively within 8 weeks from the date of such communication. Full stop. For the purpose of compliance, comma, the grievance redressal officer shall act on a server copy of this order without insisting upon prior production of certified copy. No rest to cause certain.
Great.
Thank
you.
Item 9.
I am for the petitioner.
I am going to CS.
Yes, sir.
Petitioner is a owner of a shop room and carrying on business lordship. I have annexed the trade license, applied for commercial connection twice. The CSC authority has not taken
Splitting of load, Mr. Ghosh?
No, my lord, we have caused an inspection, my lord. If the petitioner's premises is in a marketplace, which is very thickly congested, my lord. And my lord, 75 meters are already there from where all the consumers are getting supply. So, my lord, what we have suggested, my lord, in terms of our
box meter
regulation, block meter, my lord.
Block meter, I'm sorry. Not
In
box.
terms of, my lord, our regulation 53 clause 18, my lord, upon compliance and if the petitioner along with others approaches us and upon inspection, my lord, and upon compliance, we can supply them.
If I
a block
record that,
meter.
Mr. Ghosh, after that, don't give individual connection to any other person.
No, my lord.
Because that will be against you.
In that particular area, my lord, we won't give any individual connection.
Lordship, as per my instruction, there are no applications are pending. Petitioner is.
No, subsequently they cannot give you. No applications are pending.
Other than the petitioner.
You are the last straw, apparently.
Yes. We are ready to take block meter in our
Give you
network.
that leave. If you apply for
But they will have to apply collectively,
jointly.
jointly.
There is a minimum load, probably 60
Millard,
kV or
Millard,
something.
Millard, Millard. So for that, Millard, at least 5 to 10 people needs to approach us.
The minimum number of people, if they apply, then it will process there.
Subject to compliance, and there we will
Obviously.
cause an inspection.
Lordship,
What inspection you are agreeable to give?
No, Millard.
For the purpose of giving the
Whether there is any space to affix a block meter, whether the local people are agreeable to get those 75 meters disconnected, those are needs to be ascertained, Millard, because they are already 75 meters from where electricity is being catered to all the consumers, from where this petitioner is also enjoying electricity.
Lordship, I am praying only one day time to take instruction, Lordship. What is the condition?
Very good. The grievance of the petitioner is that the petitioner is running a shop in the premises in question, where the petitioner sought for a new electricity connection, which has not yet been given by the CSC Limited. Full stop. Learned counsel appearing for the CSC Limited, comma, by placing reliance on clause 18 of regulation number 53 dated April 2, 2013 of the West Bengal Electricity Regulatory Commission, comma, contends that the area is a marketplace and extremely congested, comma, where already about 75 connections have been given. First up, next para, it is submitted that if even one other connection is given, comma, it may create severe electricity and fire hazards. Full stop, next para. Hence, comma, the CSC is otherwise agreeable to hold an inspection for the purpose of ascertaining whether a block meter can be given on a joint application by the several consumers at the locale. Full stop. However, comma, such offer is dependent on a block meter being duly applied for by sufficient number of people and on compliance of our formalities by the petitioners, as well as availability of the alternative space for installing such block meter. Full stop, next para. Learned counsel for the petitioner seeks a day's adjournment for taking instruction.
Lordship, 2 days.
Very well. Seeks 2 days adjournment for taking appropriate instruction from his client on the matter. Full stop. Accordingly, let the matter stand adjourned and shall next be listed in the monthly list of May 2023.
Monthly list of May.
May monthly list means next month.
Grateful.
Mr. Ghosh, please take back this. This will be necessary in other matters.
Grateful.
Ever pass over.
Pass over matter, item 4.
And I appeal for the petition.
Yes.
But that matter, my lord, in which lordship wanted a report from the ACDCL as regards the nexus.
Must be not ready.
But may I say, may I rephrase?
This is the report.
But what had happened was, my lord, 16 decimals of land belonged to one Renukona Jana and
So that's before you go exhaustively into it, let us see whether they'll do the matter.
lordship.
Yes.
There is a huge amount of outstanding dues, my lord.
Have you given a copy to them?
Yes, my lord, I'm just.
But
Just
that is-
giving.
that is the letter which they have rejected my claim. I am on that. But the huge amount of outstanding due, my lord, that is the letter. But facts are different. But facts are, my lord, I have a demarcated portion of the land. My lord, total land was 16 decimals.
So thus, can we decide that within the scope of
My lord, lordships can, because my lord, on the earlier occasion, I had shown your lordships a judgment, my lord, in which, my lord, a nexus has to be established
Absolutely.
between the person against whom the outstanding is there and me.
Why judgment? There is also a regulation.
Lordship. Now, my lord, what had happened here was 16 decimals was the total plot of land. My lord, 16 decimals, Renukona and all her legal heirs
Yes.
sold to, my lord, my vendor.
There's a nexus tree annexed to this. You can
Yes,
check out.
lordship.
Purnachandra Mal.
My lord, I am no one with Purna Chandra. Outstanding is against Purna Chandra.
Yes, how is he connected? Where is
Yes.
There is
My
a
lord,
tree,
he's
but there is no
purchased
nexus.
property from Purnachandra Mal, my lord.
But I did not purchase it from Purna Chandra.
Purnachandra, his heir is Deepak Mal.
Deepak,
One of the heirs of Deepak Mal is Moinak.
Moinak,
Moinak and
I
Devjani.
purchased from Konika, Moinak and Devayani.
Devayani, yes.
But outstanding is as against Purna Chandra, who is the grandfather of Konika, Moinak and Devayani.
No, file an affidavit in opposition. There may be connection because
But-
just then what will happen, Mr. Das, just because I have a default, I'll just transfer it to somebody through my.
But they have to establish
This
the
is over
nexus.
generations. These transfers took place over.
No, my lord, recent sale deed, my plot is a demarcated plot. I have annexed the recent sale deed.
Yes, what do you say?
And
this-
even, my lord, may I say this?
Yes.
Out of 10 decimals, my lord, which Konika, Debayani and the third vendor obtained, they still have 3 decimals. They sold 7 decimals to me. So they are still in
Marketed
occupation.
portion was. sold.
Yes,
They are all the heirs. They are the entire heirs.
they are the entire heirs of Deepak.
Yes, what do you say?
My lord, in 4.4, after death of Purnachandra Mal, Deepak Kumar Mal, son of Purnachandra Mal, got the property of legal heir.
When was that? When did he die?
My lord, Purna Chandra died in 96, Deepak died in 2002.
My lord, kindly fixed it, my lord, 1 PM.
Not now.
Purna, I have stated that in my writ petition as well.
Yes. So you have prepared the tree from their petition. Is it?
My lord, let my lord, Mr. Nayak is coming.
But there cannot be any nexus. I am
Tell me
absolutely.
the dates, Mr. Das.
Purna
Purnachandra
Chandra
Mal,
died in
96.
96.
Deepak?
Deepak Mal died in 2002.
The rest are living, hopefully.
My lord, Deepak's wife, my lord, is still living. Deepak's wife is Konika, son is Moinak, daughter is Devayani.
Yes, it's very clear from the tree.
My lord, after the death of Deepak, Konika, Moinak and Devayani
sold 7 decimals out of
I'll
10
record your
decimals.
submissions. I'll give them 1 day's time to
Not
for Mr. Naik to come. I'll record these. A report filed by the WBSEDCL today be kept on record. Full stop. A copy thereof is served here and now on the learned advocate for the petitioner. Full stop. The stand of the WBSEDCL apparently is that the petitioner purchased the property from 3 co-owners, comma, who were the legal heirs of one Deepak Kumar Mal, comma, who, comma, in turn, comma, was the legal heir of one Purno Chandra Mal, comma, who was the erstwhile defaulter in respect of electricity charges. Full stop. Next para, learned counsel for the petitioner squarely controverts the allegation of nexus. Full stop. It is submitted that the said Purno Chandra Mal, comma, the alleged defaulter, expired in the year 1996. Full stop. Thereafter, the property devolved upon Deepak Kumar Mal, comma, who died in the year 2002. Full stop. Much thereafter, comma, only recently, comma, the petitioner has purchased the property, comma, which is a demarcated portion out of the entire property, comma, from all the existing co-owners, that is Konika, Moinak, and Debayoni. Full stop. Next para. Hence, comma, there cannot be any nexus between the petitioner and the defaulter. Full stop. Next para. Although from the report itself, comma, no prima facie nexus can be found between the alleged defaulter and the present petitioner, comma, the new applicant, comma, since the WBSEDCL seeks a day's adjournment to take further instructions on the issue, the matter is adjourned for the day and shall next be listed tomorrow. I've said everything. I'll just put a seal, take instruction.
My lord, kindly seize the report. My lord, let them correct the report.
Three is
Date of
enough.
connection is 1/1/1920. But what have they stated? Date of disconnection is 9 December 15.
Yes, Mr. Hal.
One thing is, my lord,
Who are you appearing for the
private respondent.
Achha,
I am the heirs of Deepak Chandamal. Purno Chandamal, I am not inheriting from the Purno Chandamal. I purchased, some Janas were the owners of the 16 decimals of land. From the said Janas, I purchased out of 16 decimals, 10 decimals of land. Out of 10 decimals,
how did Jana get from the
Jana by
Mals?
virtue of purchase.
So Jana purchased from Mals and
No,
you
Jana was the original owner.
Original owner of 16
Jana and
remind me on the next occasion, Mr. Haldar, I'll record that also. Because in any event, I have held virtually in their favor, but they'll take.
Anyway, related to this property.
একটা লাইন অ্যাড করে দিন মেঘনাথ যে it may be recorded further, last sentence টার আগে, it may be recorded further that it is submitted by the private respondent, comma, who appears for the legal heirs of Deepak Chandra Mal, comma, that you purchased from somebody else.
I purchased, Deepak Chandamal purchased from
That
Janas.
Deepak Chandra Mal purchased the property from the Janas and did not inherit the same, comma, from Purno Chandra Mal. Full stop. তারপর be that as it may করে adjourned.
Lordship.
Show me this order tomorrow.
Lordship.
Remind me. Yes.
Contempt application item 10.
I beg to appear as petitioner. On last occasion, your lordship has been pleased to file an affidavit in reply on their behalf.
Here,
I'm filing the same.
where is the alleged contender? Mr. Debra is the opposition. Yes.
And here,
What is the alleged
Order has
contempt?
been complied with, my lord.
lordship, let me allow some to submit some points.
Definitely. Take your seat, Mr. Debra. Yes. What is your point?
Lordship,
They
this
say order has been complied with. What is your instruction on this?
Lordship,
Take the microphone, ma'am. Please take the microphone. Yes.
this contempt application was contained of the consideration of the representation dated 3rd of January 2022. And that representation was contained of twofold facts. One, there is a consideration of illegal and unauthorized flying of the e-rickshaws towards throughout the district of Durgapur. And the second point is the consideration of the registration of the battery operated eco-friendly e-rickshaws. And so far the consideration of the first point of illegal and unauthorized plying of the e-rickshaws, the department has got the step on after elapse of 9 months to 10 months of filing this contempt application. Prior to that, your lordship has been pleased to direct to take the action within 1 month. That has not been done. And there is a speaking order passed by the department on 16/8/2022, where in the bottom portion of the that representation, it was clearly said a copy to that action should be shared with the petitioner. That has not been done. And after direction from the from your lordship, that copy has been sharped on the earlier occasion. And
Don't send them to jail for this.
no, lordship, I'm not on that. And second consideration of
The unfortunate thing is that you are right on one aspect of the matter. These contempt applications are taking the shape of execution petitions now. Before a contempt is filed, they do not comply. That is a reality.
Lordship. And
unless their advocates interfere, they don't.
Lordship, it is, I agree with this. And on the
There is no contempt now. I'll drop the contempt.
Lordship, so far the consideration of the registration, that registration has been half done with the person, that is Ganesh Prasad namely, and that without prior notice or everything, that has been stopped. And that is the interference of the civil suit of 27.
That's furnishes a fresh cause of action for you. That's a different argument. On that, you have to argue on that. The limited scope was to consider your representation. They have done it, but done it severely belated manner.
But all the manufacturing companies are dealing with the registration right now by the order of the coordinated benches. And lordship, this dealer has been hampered by many ways. He has been sent several applications on many occasions. Department is not taking the action. Only of filing different read petitions, contempt application, they are moving their head. Otherwise not.
That's a general allegation.
Lordship,
this contempt does not lie for that. That is a difficulty. Our scope is very limited in contempt. I'm not hearing a writ petition.
Subject to some indulgence, lordship. Only the poor person, that is Ganesh Prasad's registration has been done.
Who is poor? Nobody is poor here.
This auto has got scrapped. Disclaimer is ready. The registration had got stopped. And on the last occasion, your lordship has been very much pleased to not to interfere in the matter of the title suit. That has been depicted in the order on 29th of June 2022.
They have complied with the direction to consider the representation. Yes. They have taken certain steps further. That steps you are not satisfied with. So you have to take out a fresh cause of action. That's a fresh cause of action for you. Your limited scope was that representation. Maybe I understand your predicament. At every step, you have to come up before the court with another application.
Yes, lordship.
But I mean, if it's a fresh cause of action, the court's hands are bound within the contempt jurisdiction. That is the difficulty.
That
definitely, if there is any patent contempt still persisting, deliberately continuing it, definitely they can be sent to jail. They should be, or whatever else.
First, I have filed the writ petition in the year 2019. That has been withdrawn by your lordship.
I did not withdraw.
No. On the, I'm saying.
Don't use your lordship in every. Let me do it.
In addition to this,
yes, please add.
If my lord allows.
Yes, definitely I will allow. Yes, what?
First, definitely rightly she submitted. Is this why the contempt petition?
This is a microphone.
Why the contempt petition is filed before lordships?
Yes.
In the original writ application, my lord has got the elaborate order over the matter. And on 29th June 2022, there are two parts of the order. One part is to consider the representation, which was
and to take action.
Yes. And the second part is there is an allegation that so many illegal e-rickshaws has been plying throughout the area. So the department has not taken consideration about the matter after giving repeated reminder to the petitioner. Even my petitioner is also. Now, what happened? They have considered the application representation, but pending the inquiry report. They have considered, they heard out the matter, and my client was present there and heard out the matter, but the inquiry has not been done by the concerned authority, but it was the speaking order of lordships that both the matters should be taken together and to inquire about the matter. But pending the inquiry, they have just considered the representation. That is the grievance, and that is the deliberately just violated the order of your lordship's order.
No action has been taken.
No action has been taken relating to that matter. The illegal plying, this is our allegation that so many e-rickshaws, like I am the distributor, so I got the registration earlier. There is no reason to discard my registration. But in this context, my submission only that so many distributors getting the registration. Why this person is not getting the registration? That is the one thing. Well, in this context, my submission before lordship, what is the problem on the part of the transport authority to not give any registration to the dealer? This petition particularly, he was given earlier. So mere pendency of the civil suit is not barred to giving registration to that.
Claim in the suit. You're a party to the suit.
And in this context, more say I like to submit before lordship.
Not a part of the contract.
Well, one thing. So I'm not on that, but definitely it should be considered that
Not in this matter.
the coordinate bench of this court has given the registration in so many occasions.
Contempt
in
cannot be considered.
No, right. My lord, in this,
record my order now.
my lord can do one thing. My lord can do kindly call for a report why the registration has not been given, why the illegal authorities, illegal e-rickshaws is just flying.
Petitioner argues
Just one report may kindly be called for.
that
What problem
a
is
report-
there?
That a report be called for from the alleged contemners.
Yes.
As to what action has been taken? What is the language of your report?
Yes, what action has been taken by the transport authority regarding the illegal e-auto rickshaw
What
flying in
action has been taken by the transport authorities regarding illegal plying of e-rickshaws?
Yes.
Full stop. Next para, it is further submitted that the order of this court was not complied with in due time. Full stop. Although a direction was given to consider the representation in question, preferably within a month from the order of the court, comma, the same was done about 9 months thereafter. Full stop. Next para. Peruse the affidavits in opposition and reply filed in court today. Full stop. The stand of the alleged contemners is that, comma, although late due to procedural wrangles, comma, the order has ultimately been complied with by considering the representations and taking appropriate decision thereon. Full stop. Insofar as the further action not being taken by the alleged contemner, comma, as per the allegation of the petitioner, comma, it is seen from the order dated
29th.
June 29, 2022,
Yes.
passed in WPA 11403 of 2022, comma, that thereby the alleged contemners were directed to decide the representation of the petitioners upon making proper inquiry in respect of the allegations leveled by the petitioners.
Yes.
Full stop. However, comma, even if the petitioners now argue that inquiry was not properly undertaken, comma, the same would be beyond the scope of the contempt application, comma, to the extent that the opposition discloses that steps have been taken properly by the respondent authorities. Full stop. Next para. Even if the petitioners have any grievance in that regard or regarding the ultimate conclusion arrived at by the respondent authorities upon such representation, comma, the same furnishes a fresh cause of action, comma, which cannot be decided within the limited scope of the present contempt application. Full stop. Further, comma, in the order of which contempt has been alleged, comma, it was specifically clarified that the court had not touched the merits of the interim order of injunction bearing order number 27 dated February 24, 2020, passed by the additional district judge, comma, 13th court at Alipur in title suit number 27 of 2018, and that the plying of e-rickshaws by the petitioners and all other dealers stroke operators shall abide by the ultimate outcome of the said suit and stroke, or if any further order is passed in modification or vacating the said order of injunction by a superior or a collateral forum. Full stop. Next para. In view of such specific findings, comma, it would be premature to adjudicate on the issues now raised subsequently by the petitioners in the contempt application. Full stop. Hence, comma, in view of the discussions above, comma, it is seen that although late, comma, the order of this court has been complied with.
My
Full
lord,
stop.
there is no late.
Yes, definitely 9 months.
What no read?
June and order complies
I have
with
not
July.
recorded any date. Full stop.
No late.
Next para. Complied with and comma as such, comma, nothing remains in the contempt application. Accordingly, CPN 136 of 2023 is disposed of without any orders to cost.
Deeply obliged.
So, however, it is made clear that in the event the petitioners are aggrieved by the subsequent action taken by the respondent authorities, comma, it will be open to the petitioner to approach the appropriate forum, including a writ court, comma, with the said grievances. Full stop. This court has not prematurely gone into the allegations made by the petitioners on such score. Thank you.
Well, kindly appreciate on the difficulties is this. What is the problem? Because some of the distributors given the permission. So I'm abide by the order of the learned court also even guideline maintaining the guideline of the transport authority. Apart from this, they are restraining myself.
Then Article 14 is violated. File a proper application. Why should I advise you? If you say that if you are on equal footing, unless there is reasonable classification, everybody knows that.
Several manufacturers
File a proper application, get your
code
relief
number 5
there.
or code number 10.
I'll come back in 10 minutes for the next matter. This matter is over.
Deeply obliged, my lord.
Okay.
Application item 11.
My lord, I beg to appear for the alleged.
Gitanjali.
There was a direction for filing affidavit, my lord. May I file, but a minor fault has been committed by me. Direction was to file affidavit by 20th April. But my lord, it was served on 24th April to my learned friend appearing for the petitioner. He was supposed to file the reply by 25th, since the affidavit.
How many contemners are there, Mr. Kali?
My lord, there are 4, but the principal secretary law department is filing he is the head of the hierarchy.
No, contempt to all of you have to file.
No, but these, yes, I fully appreciate, my lord, but these other contemners have not come forward to, because since he is in a position to comply with the lord's order.
No, even then, Mr. Kali, there was a specific direction. Unless all of them file, I have to issue a rule then against the non-filing persons. I'll extend for 1 week more, Mr. Gali. Please
Other
ensure
contemners.
others, even if they say his liability
That
or
we
whatever, you know the usual.
Lordship.
At the time of call, only the alleged contemner stroke respondent number 1 files an affidavit in opposition, which is accepted and kept on record. Full stop. However, in contempt applications, since the allegation is at an individual level, all the alleged contemners are required to file affidavits. Full stop. As a last chance to the rest of the alleged contemners, the time for filing opposition is extended for a week from date. Full stop. The time for filing reply is further extended for a week thereafter. Full stop. The matter shall next be listed on May 17, 2023.
Lordship.
17th May, Mr. Gali, please just ensure that
Lordship.
at least nominally these oppositions are there. Even if they're not responsible, they have to say that.
Lordship. Grateful.
If you can, please intimate your learned advocate for the petition.
Yes, certainly. Mr. Mukherjee is there.
Old matter. Item 12.
Lordship has accepted this affidavit.
Yes, I've recorded.
Item
Only
12.
the rest of the contemners have to. Yes.
Item 12 and 13.
Yes, Mr. Order.
My first yes.
Only, if your logic can take.
Mr. Prasad, can you please use the microphone? Yeah.
Next Wednesday, my lord.
I have no difficulty. Yes.
Because the code number 4 only taking up tribunal matter only on Wednesday. That is it.
Today is that day.
Date, my lord.
Very good. On the prayer of learned counsel for the petitioners, the matter is adjourned till May 3, 2023, 3rd May, Wednesday.
Part third matter. Item 14.
I am for petitioner, my lord. Submissioner appearing kindly fixed at 2 p.m. He is busy in court number 13.
My lord, then.
Whatever your learned friend says. Friday.
Yes.
Mr. Shubhishanal is for the licensee?
Petitioner.
For the petition.
For the petitioner.
Yes.
An adjournment is sought on behalf of the petitioner. First up, let the matter stand adjourned till April 28th, 2023, Friday. You come prepared on the next day on the matter, even if Mr. Shanal is not there. Come prepared. You are also in this matter. Come prepared.
For hearing, item 15.
It is here.
Item number 15, my lord. My lord, item number 15, I beg to appear on behalf of the petitioner, my lord. Am I audible, my lord?
Audible, not visible. And why are you online?
My lord, due to some, my lord, physical difficulty, I have, my lord.
Yes, what is the matter? What is the matter?
My lord, the matter is very short matter, my lord. What happened is, my lord, my contention is only that the licensee authority did not issue bills, my lord, after, my lord, passing a quite long time. Now, my lord, when they have appeared, my lord, I came to know that, my lord, I have been, my consumer ID, allegedly, my lord, have charged as, my lord, charged as my lord pilferage. Now, my lord, in their reply, my lord, they have stated that my son, who is my lord the responsible for that alleged pilferage. My lord, my only humble prayer before your lordship is, my lord, my lord, I am ready to willing, my lord, the charges, my lord. But my lord, may kindly grant me some, my lord, adequate opportunities to, my lord, pay the my lord final assessment bill, because, my lord, whatever has been done, I have no knowledge about that, my lord. I have sent them the, my lord, advocate notice in that regard.
What is the total amount of assessed charges?
My lord, they have,
My lord,
they have
3,43,724.
3,43,724. My lord, I have sent them my advocate notice, my lord, that why you have not issuing bills, what is the matter, what happened. They have not answering, my lord, anything to me. Only, my lord, when I filed this writ petition, they appeared, and, my lord, I came to learn about all such things, my lord, that my criminal proceeding also, my lord, filed against my son. But I have no knowledge about that, my lord.
10-year-old cultivator. All the indicators are there. So, how long will you give them? I mean, take instruction. Mr. Naik, you've heard me. 77-year-old cultivator cannot pay for pilferage charges. He will pay. How much time can you give him? Maximum. Take instruction, come back there.
Leave it to the court.
Take instruction. If not possible, then we'll decide. Otherwise, Mr. Pal, unless they, there is a question of concession, but unless they have some instruction on this, I cannot saddle them with this, because section 126, 127.
That is there, my lord. That is there.
One is very clear. I cannot
That
buy.
is there. That is there, my lord. My lord, that is there. That is there. I'm not disputing that.
Have you preferred any appeal against the?
No, my lord, because I don't have any knowledge about the whole
Son has
proceeding, my
preferred-
lord.
You have knowledge about your son. Has he preferred any appeal?
My lord, so far I have the instruction, my lord. My lord, I don't know what he has done. I don't know.
The Pal, because you are 77 years old, you have been set up by your son after committing the pilferage, and you have not even challenged. He has not even challenged. Now you say, I don't know anything, and you are coming up for this electricity. So beneficiary will be your son, against whom allegation of pilferage is there.
My lord,
you cannot take advantage of your age.
So far the beneficiary is concerned, my lord, I am still in dark. That is the,
Son is also there. You are also there. The electricity connection is in your name.
in my name, my lord. And they did not, my lord, they did not communicate a single, my lord, a single letter to me.
How much can
Whatever
you pay?
they have,
Sir Pal, how much can you pay immediately?
my lord, that I need to take instruction, my lord.
You are not with
immediately.
instructions. Then I cannot permit you. I'll give the liberty to you to approach the CS, WBSCDCL. They'll decide.
My lord, only one chance, my lord. One chance.
That chance will be before WBSCDCL. I'll record something in my order in your favor, so that I mean, whatever. Learned counsel for the petitioner contents that the petitioner is a 76-year-old cultivator in whose name the alleged defaulting electricity meter is standing at the premises in question. Full-stop. Allegations of pilferage have been leveled against the petitioner's son, and the connection has been severed by the WBSCDCL. Full-stop. It is submitted that the petitioner be permitted to get restoration of electricity connection upon easy installments being given for payment of the assessed charges. Full-stop. Next para, the scope of sections 126 and 127, read with section 135 within bracket 1 capital A bracket closed of the Electricity Act 2003 is very restrictive. Full-stop. Hence, the court does not have any jurisdiction as such to prolong the time for putting in the alleged sum. Full-stop. However, keeping in view the advanced age of the petitioner and the predicament he is suffering as a cultivator, it is expected that the WBACDCL, if approached by the petitioner, shall consider the case with sympathy and grant some installments to the petitioner to pay the entire assessed amount, if possible. Full stop, next para. Accordingly, WPA 4761 of 2022 is disposed of in the light of the above observations, granting liberty to the petitioner to approach the WB ACDCL with his fare for installment. Full stop, if so approached, comma, the WB ACDCL shall decide such approach sympathetically. Full stop, no orders to cause urgency.
Grateful.
I'm grateful, my lord. I'm grateful. I'm grateful.
16.
Mr. Devjit Mukherjee is appearing for the CAC, my lord. I'm paying for short passover, my lord.
No password, you are there.
My lord, in this matter, my
He has
lord,
filed affidavit, not the CAC. He has already filed affidavit.
No, on the last occasion also. No, let him start the matter. Yes, Mr. Pacha.
Lord, my application for new connection made. Lord, the assessment, the inspection, Lord, the amount charged for security deposit, I have deposited the amount since long, Lord. Since the private respondent is objecting to such application, Lord, that's why not the supply could not.
What is the objection from their
objection? Lord, they have filed their affidavit. In the affidavit, Lord, they have stated with regard to the filing of a civil suit against the port trust, since the property belongs to port trust, and there the order of status quo is there. Now they have challenged, without stating their status, not as right title interest, they have challenged the right title interest of the petitioner. That is the affidavit.
Who are you in respect of the property?
Well, I am running their business, a family property, Lord. The objector, Lord, the private respondent, also one of the family member, Lord. It is a feud between two, Lord, the brothers. Lord, I am
The port
running
trust has initiated proceeding against them.
against the port trust. That has nothing to do with this case, not that port.
Who has initiated against whom? The civil suit, let us see.
Not the predecessor of the private respondent.
Not your predecessor.
Also my predecessor.
Has to be, because you're
obviously not. Also my, because the direct, not the, he is the son of that person. Not that's why not.
I have annexed my trade license. And
Not, you kindly see, I am running the business. I had the telephone connection, trade license, every document, the bank statements, all through.
So what is their best case, Mr. Pachal, since Mr. Mukherjee is not there? What is their best case from the opposition? Are you for
Mr.
them also?
Mukherjee for the CSC, they are agreeable to provide.
You are for the CSC?
Yes.
They have taken money already.
You have served on the private respondents.
Yes, they have filed their affidavit.
If you are agreeable, then I'll
They have taken money, accepted money.
We are agreeable.
Yes, we are agreeable.
Well, in my instruction, we are agreeable.
Thank you. None appears for the private respondents when the matter is called on for hearing. Full stop. Learned counsel, what is your objection, Mr. Mondul? Pendency of a suit.
No. That is not.
What is your objection? Take the microphone.
My lord. That is my possession, my lord. That is my possession. He has no locus standi, because the property is the port trust. I am the leasehold, my property, my lord. This is my leasehold property. Kindly consider my photograph, my lord. I have already annexed, my lord. This is a open space, my lord, bounded by the wall, my lord. I am running the business from long time, my lord. After 15 years, I have obtained a stay, my lord. The court has directed to
Obtained a stay against whom?
against the port trust, my lord, not to disturb.
They are not a party there.
No, my lord. Here.
Mr. Shen is
I
there.
made my mistake.
No, Mr. Shen.
I made my
Please, yes.
But the point is that I am in actual physical possession of that entire area. My learned friend has to show his possession physically. Apart from, I know, there usually prima facie case is made out on the basis of certain documents. But unfortunately, in this case, I have these same documents from a previous period of time.
No, sir.
I was only praying this, this let a physical examination take place who is actually in physical possession.
Mr. Shen, that would be very difficult because if the CSC or the whoever the licensee
CSC will do that.
CSC is permitted to do that, they don't have the authority to ascertain possession. That will be a very risky proposition.
So then your lordship will appoint a special officer to find out who is, because it is a case of actual physical
The
possession.
nicety of the that after filing of the writ petition, one declaratory suit has been filed by the private against me.
I'm saying that let us forget everything.
Yes.
But let us find out who is actually in physical possession, because I
am in possession. There are documents to speak for itself.
Mr. Shen, you are not enjoying electricity there.
Yes, I am.
There is a previous connection there.
Yes. Previous connection,
no
existing
no
connection. I am paying bills.
If an independent connection is given to them, you are saying they are not in possession. That's a disputed question.
Yes.
There is no suit pending between you and him.
No, recently they have.
Yes, I have filed a suit.
After filing of the writ
Yeah,
petition, that has
no
done.
injunction, nothing.
Well,
No, no.
point is, I was saying that there was no impediment.
Visual inspection of physical person, Mr. Sen, is very risky.
Well, one special officer to give a report.
That will affect the suit.
No, no,
Special officer will go there and visually inspect.
Find
Now,
out.
on that
Malad.
fine morning, you may be there, you may have ousted them or vice versa.
Your lordship will kindly see some of the documents which I am relying upon. Malad.
Yes.
There is an eviction suit filed against me by Port Trust.
Port Trust.
Port Trust cannot admit your possession on their behalf. That is a difficulty, Mr. Sen.
But I have filed a
I
supplement.
file an eviction suit against you. Third party rights cannot be affected by that. If they may be in actual possession, it may be a collusion between you and Port Trust.
I am not, Malad, let us not go into that. I just.
On the contrary, my lord, apprehending my disposition, they have filed a suit against me.
To you before passing my order, Mr. Pachal.
Malad,
How can I without hearing you
supplementary-
pass my order?
Supplementary affidavit to file for us?
What supplementary affidavit?
Just to show them documents, Malad, my documents.
He was granted previously.
Yes.
He was granted.
Service করেছো?
ঠিক না, এগুলো সব আমাদের তো।
Yes.
First of all, my lord, this is the page 4 onwards, your lordship will see, addressed to me, professional tax notice from the Howrah Municipal Corporation, my existing meter at the same address, page 5, and I have given photographs of the entire boundary wall.
Mr. Sen, your possession may not be mutually exclusive with theirs. It may very well be that both of you are in
That
possession.
is what I want.
So their prima facie, what they have shown regarding their possession, that is only to be seen by the licensee.
I
This is only on
accept,
that.
but it cannot be that, my lord.
It will not create any equity or right in their favor as
It
usual.
will amount to an encroachment. Then once an mandatory order is passed,
No,
I
that,
will have-
that-
I
no,
will
that
have-
it will be clear in the order, Mr. Sen. It has to be clear in the order that there no equity or possession will be
No,
created
very
merely by virtue of this document. That has to be there.
Yes, well, it will be.
In any
But
event,
I
that will
just want, my lord, the court to get a picture of the situation.
Court getting a picture in a writ petition in connection with this in an electricity matter, Mr. Sen, on the possession, even in a suit that you know that it's very risky.
Only-
Visual inspection possession is very risky.
But here,
On that particular day, whoever is stronger, that prevails.
but here it will come, my lord, this person on the strength of the electric meter can get into possession.
How? I mean, no.
But
Let us see
my lord,
from the writ petitioner, Mr. Sen, I'm sorry, Mr. Sen demolish their documents prima facie.
yes,
Apart from your documents of possession, because I don't think they are mutually exclusive.
supplementary affidavit.
Opposition.
But if your
In
lordship,
their writ petition, they have added certain documents. What is your rebuttal to that? Apart from your possession documents?
but one order, if I will show your lordship, my lord,
Whatever,
from the
whatever.
affidavit in opposition, one order.
Very well, yes.
Page 54. হ্যাঁ, আমার against এই যে
This is the opposition of 5 or 3?
5.
5, yes.
আমার আমি সুট ফাইল করেছিলাম সেখানে appeal ওরা হারলো, কোর্ট ট্রাস্ট হারলো, তারপরে এখানে রেকর্ড করে রয়েছে, পুরো জিনিসটা রেকর্ড রয়েছে।
It is
appeal অর্ডারটা তার আগে রয়েছে।
in the suit inter se me and Port Trust. Kindly see, my lord, the order dated 27th July at page 54.
Yes.
হ্যাঁ, লিখেছে কি কি আছে।
Plaintiff's contention during the pending suit, sole proprietor of the plaintiff firm died during pendency, proprietorship firm changed or converted in registered company.
That is order 2010.
Yes. And this has recorded everything.
Previously, an injunction was granted against the Port Trust probably. They preferred a miscellaneous appeal against that. From the previous page, it appears that that was affirmed.
Yes.
So you are enjoying an injunction against the Kolkata Port Trust at the present moment regarding your possession. Or injunction or status quo? Status quo probably.
Status quo.
Status quo.
Status quo. If it's status quo, both plaintiffs and defendants, page 17 probably. Plaintiff and defendants are directed to maintain status quo in respect of the suit property as mentioned in the schedule of the plaintiff. Now, this status quo, Mr. Sen, cannot clinch your possession against them. We cannot say beyond doubt they are not a party there.
Is their documents.
Their documents you have to demolish. Prima facie. This is certified by 1 Jagat Banerjee Ghat Road.
Yes.
35/1. But question is, well, to get a trade license, I will have to show something of it. This is not again, my lord, a very prima facie document.
Not a very prima facie document.
At
Mr.
least
Sen, you are right.
It may have been done behind my back.
One judgment was cited by Justice Joyanta Vishwas probably yesterday only. That's why I remember. No other reason. That there the trade license presumption was disputed. That judgment it was held that trade license, yes, per se it is not a proof of the right to conduct a business even. I mean, or they are conducting a business, something like that's vis-a-vis the business. But it is conclusive, at least prima facie, not conclusive, prima facie evidence for the contents of that application for trade license or the trade license itself. The contents include the possession, Mr. Sen. Prima facie, absolutely prima facie.
There is a telephone bill. Kindly come to page 13. If it is a, I actually.
Both of you may be in person. If they had to take possession by hook or by crook, then they have already got these telephone bills issued in them. So this will not add anything to that.
Let a police officer of the local area.
Please, Mr. Sen,
Then,
don't tell me that.
I think it is best an advocate, my lord. Just let him go and give a report, and whatever your lordship will feel on the basis
That
of
will
that
delay
report,
the entire thing.
and let him.
That inquiry cannot be gone.
But may I say
This is sufficient for
and a
getting in.
surprise inspection,
Not
surprise visit,
in addition,
without notice to any of the parties. When he will
In the scope
go,
of this petition, Mr. Sen, that will be a dangerous precedent. Definitely.
First day they are trying to let it.
because this fact that
I'll give my reasons why it will be a dangerous precedent, because you have argued that specifically. Definitely, I'll have to record that, but that I'll refuse because that will set a dangerous precedent.
because
Very limited scope of the writ petition first. Secondly, visual inspection by an officer of court.
can I seek one indulgence, my lord? Kindly keep it tomorrow. Talk, my lord, I will make a submission and conclude it, my lord. A little bit, my lord.
was finished for day one.
Since
it is-
day one.
This will be item number 1 tomorrow then, Mr. Sen, because it's their consistent grievance that you are signatory. Very well. Learned counsel for the petitioner, by placing reliance on the documents annexed to the writ petition, submits that such documents palpably indicate that the petitioner is in possession of the disputed property where a new electricity connection has been sought. Full stop. The CSC Limited, in principle, does not have any objection to give new electricity connection at the said premises in the name of the petitioner, subject to compliance of formalities. Full stop. Next para. However, learned senior counsel appearing for the private respondent contends that the private respondent is in possession of the property, which has been prima facie established by virtue of injunction orders passed by the trial court as well as the appellate court in a suit filed by the present private respondent against the Kolkata Port Trust with regard to the same property. Full stop. It is contended that the status quo order passed in such suit, which has been annexed to the affidavit in opposition of respondent number 5, clearly indicates that the petitioner, that the private respondent is in possession, which excludes the possibility of the petitioner being in possession of the same property. Full stop. Next para. It is further contended on behalf of the petitioner, on behalf of the private respondent, that a surprise inspection may be held on the direction of court by waiver, including an officer of the court if necessary, to ascertain as to who is in actual physical possession of the property at the present juncture. For next para, it is seen prima facie from the materials annexed to the pleadings that the petitioner and the private respondent have a contentious case as regards who is in possession of the property. Full stop. However, the local inspection or visual inspection as sought by the private respondent would set a dangerous precedent in the opinion of this court, comma, since such fact-finding exercise within the scope of the present writ petition, comma, which is of extremely limited scope, comma, since only the obligation and the authority of the licensee to give a connection is to be tested, comma, to make an inquiry as to who is in actual physical possession of the property, full stop. It is all the more so because a suit is pending between the Kolkata Port Trust and the private respondent, comma, where the petitioner is not a party, full stop. Any observation in a visual inspection report filed in the present writ petition might adversely affect the interests of either of the parties in such suit and or the rights of the present writ petitioner, which is not a party to the suit. Full stop. Next para, hence, comma, such prayer for appointment of a special officer to ascertain by visual inspection the actual physical possession in respect of the property is refused. Full stop. However, comma, on the prayer of learned counsel for the petitioner of the private respondent, comma, for advancing further arguments by the private respondent, comma, the matter is adjourned till tomorrow when it will be listed immediately after the new motions. Immediately after the new motions, sorry, true. After the new motions tomorrow. About 4 or 5 probably. Mr. Shen, please ensure that you are there tomorrow because whatever you have to submit, I'll definitely.
Yes.
Prior facie, I'm against your client.
I would have thought, my lord, this finding regarding inspection, if I could have convinced your lordship tomorrow. Your lordship actually expressed your lordship's view today.
So that's why.
I wanted to, for that purpose, I actually wanted, because well, it may not create a precedent at all. It is only for the purpose of this adjudication of this particular issue.
If you have something convincing, Mr. Shen, you can argue tomorrow. I'll definitely listen to you. If I think that my opinion is required to be changed, I'll give my reasons and change my opinion, subject to your convincing. Oh, you're in a different matter. Sorry. Yes.
17.
My lord, on behalf of the petitioner, my lord, I'm praying for a not today, my lord.
Why?
My lord, Mr. Hussain is appearing in this matter, my lord, due to some personal difficulties, my lord, he is not able to do the matter today, my lord.
My lord, come to court.
Mr. Hussain has, my lord, submitted it on for Monday, my lord, that he will be out of station.
Oh, yes.
But due to some personal difficulties, he cannot do the matter today, my lord.
My lord, I'm for the private respondent, my lord. In this matter, already a writ petition on a similar matter, they have dismissed. It's they are the landlord, my lord. They are restraining for the new connection, my lord.
Call your client's representative. I'll convince him that I'll take it up tomorrow. You are not at fault.
I'm obliged, my lord.
On the prayer of the petitioner, the matter is adjourned for the day, only for the day. Please come prepared tomorrow. If he is not prepared, you have to move the matter or whoever else.
Assigned matter. Item 18.
For the preemptive opposite party.
In this matter, Mr. Shushanjit Bonik is appearing for the petitioner. Because of he is out of station, I am praying not this week.
Depending on Mr. Das.
Only one thing, my lord.
Yes.
If your lordship hear this matter, I do not object to that. But your lordship's father is appearing in the.
Oh,
well,
thank you for pointing out.
No, my lord. If your lordship hear the matter, fix a date for hearing 99 matter.
That is the impression you have of me, Mr. Das, after so many years.
That is
thank you for pointing out.
It
would be embarrassing
at the very outset. I submitted.
Thank you very much for that. It is fairly submitted by learned counsel for the private respondent.
No.
You're
for an opposite. Your lordship fathers appear.
Civil division.
On behalf of the preemptor.
Appearing for the preempt.
You
are preemptee or preemptor?
I am preemptor.
Advocate for the preemptor stroke opposite party, that in view of my father appearing in a connected proceeding in the trial court, comma, this matter ought not to be taken up by this court, full stop. In view of such contention, comma, on my personal grounds, comma, the matter is released from my list with liberty to the parties to mention before the appropriate bench and or seek an assignment before the appropriate bench.
The very outset,
Thank you so much. I can record my thanks to you in my.
no, not that, my lord, not that.
No, thank you. It would be an embarrassment for me unnecessarily.
Because I've gone through the brief, my lord. Your lordship's father has
Thank you.
succeeded.
You are saying that is sufficient, Mr. Das. Yes. Call on the next one.
Item 19.
Petitioner.
Yes, my lord.
Yes. What is your case?
My lord, in this case, my lord, very old case, my lord. Petitioner is senior citizen person and
Take the microphone. Please.
he going to some repairing work for his own house, but the adjacent.
Said he's a senior person going for some repairing work. I thought his own.
No,
repair.
but his.
Anyway, what do you want? Tell me that.
But the adjacent plot owners and neighbors are obstructing and restrain the petitioner from the repairing works. As such, petitioner made 144 application, filed 144 petition before the executive magistrate court and order in favor of, and they are.
He has now repaired.
But despite of order, they again restrained and obstructed. Thereafter, petitioner made written complaint to the concerned police station and case has lodged. But the matter was petitioner filed prior to this writ petition. Petitioner filed another writ petition, which was moved before the Honorable Justice Devanshu Bosak, and after that, Honorable Justice observed that there is a permission from the concerned Gram Panchayat. Thereafter, petitioner withdraw the petition with liberty to file afresh, and petitioner thereafter taking permission from the concerned Gram Panchayat, and petitioner thereafter trying to repairing it. But till now, that part not repaired by the obstruction of the private respondent. That is the matter.
It is a private dispute then.
Not private dispute, because it is the repairing work for the house of the petitioner is the owner of the petitioner sole owner. But private respondent, they are the
occasion of filing a writ, police in action.
Prior to that, police in action, but thereafter, after permission of the Gram Panchayat, that is confusion that what is police in action or the Panchayat matter. That is the problem, my lord.
2018.
That is, petitioner seeks actually police assistance.
This is of which year? 2018
matter.
So I don't have determination in any event.
Assigned matter, my
lord.
lord.
Assigned matter.
Assigned matter, my lord.
Give another notice to the state, come back tomorrow.
Notice. Only notice.
Just a notice.
Yes.
To the state's advocate will do.
State advocates are now assigned or not, I may not know.
Ascertain that you have your own sources at the bar. Ascertain today. None appears for the state when the matter is called on for hearing. Full stop. Learned counsel for the petitioner submits that the petitioner is seeking to repair his premises and has obtained appropriate permission from the local panchayat for doing so. Full stop. However, comma, due to inaction on the part of the respondent authorities, comma, such repair work could not be completed till date. Full stop. Next para. However, comma, to give another opportunity to the respondents to appear in the matter and contest the same, comma, the learned advocate on record for the petitioner is requested to serve a notice to the learned advocate for the state, indicating that the matter shall be taken up under the same heading for hearing on April 28, 2023, day after tomorrow. You'll get 1 day's time. Please try to give a notice to whoever is to the GP office or whatever.
Yes, yes, obliged. 28 April.
Item 20.
But I beg to appear on behalf of the state respondents.
Yes.
I am for the petitioner also.
Yes.
So the petitioner is the owner of the landed property. The private respondent number 8, 9, and 10
illegally construction on the Gangasagar and Kochuberia Road, Lordship, thereby obstructing the free ingress and egress of the petitioner, Lordship. The petitioner made representation before the authority concerned for removal of such illegal construction, but that was not removed till now, Lordship. Therefore, the petitioner is deprived from illegal.
What steps have you taken?
Lordship. And in another same putting, Lordship, the coordinate bench passed the order for consideration or representation and for
For
removal
consideration of representation, you are
and
citing
for-
a judgment.
No, Lordship, not judgment, Lordship, on similar
what he
petition
did,
putting,
Lord?
Lordship, and for
Yes, I am
removal-
bound by this judgment to
No,
direct
Lordship,
consideration and
I am
representation.
saying so, Lordship. That is not precedent. But for removal of illegal encroachment, if any done by the
I'll
respondent.
copy paste this order.
Lordship, we have already initiated process under section 10(1), 10(2), and 10(3).
You have already initiated.
We have already.
They ensured that that
Yes,
reaches
Lordship,
logical.
certain time, Lordship.
Indicates, my lord, the entire exercise will be completed within a
At a certain time, Lordship.
What should
The
be a
time-
reasonable period? Tell me.
3 months, my lord.
Sufficiently fair.
3 months.
3 months.
Fair enough. You were waiting for 3 years.
Yes, no, no.
Sufficiently fair. Learned counsel for the petitioner submits that the petitioner gave a representation to the respondent authorities alleging certain illegal construction being made on public property. First up, it is submitted that such representation has not yet been decided and no steps have been taken thereon by the respondent authorities. First up, next para, the representation of the petitioner is annexed at page 12 of the writ petition. First up, next para, learned counsel appearing for the state respondent authorities submits fairly that in the meantime, steps have been taken for eviction of unauthorized occupant of the property.
And proceedings under section 10(3) is pending. my lord.
And proceedings under section 10 within bracket 3 of the Highways Act
State Highways Act.
of the West Bengal Highways Act
Yes.
are now pending. First up, next para, in such view of the matter, WPA 3915 of 2020 is disposed of by directing the respondent authorities to expeditiously dispose of to ensure that the pending proceedings are expeditiously disposed of, preferably within 3 months from date. First up, no arrest to cause certain.
Next two matters are identical. matters.
Same order, then nothing. WPA number is different.
Yes.
Next two matters, you are appearing for the
Yes,
petitioner.
yes, Lordship.
And you are for the respondent. Very well. Yes.
21.
21.
22, 24. 22, 24.
3915, WPA 3916 and 3917.
3917.
Up to the matter where your name is appearing.
24, Lordship.
Up to the name, up to the
Yes.
matter where your name is appearing. Similar matters.
No, my lord, I am 3917, my lord, I am appearing. Item 22.
Yes. Lord, I beg to appeal this state respondent.
22.
You are for the petitioner.
I am for the
I am
private.
petitioner.
Private respondent, what do you say? They have initiated, you have initiated proceeding in all the matters.
Yes.
They have initiated proceeding. I have directed them to.
My lord, I have some submission. My lord, the petitioner, my lord, claiming that he is owner of the plot. My lord, what happened? Petitioner father was, my lord, obtained the patta in terms of section 40.
We cannot go into the title dispute here.
No, no, I'm not on that. My lord, after obtaining.
The question is whether you are unauthorized or not. They will decide in that proceeding. They have initiated.
That
The hearing he can raise.
You will have a hearing there.
My lord, for a minute.
Hearing.
No. Let him submit. Yes.
My lord, petitioner father, my lord, already gifted the land to the school in violation of section 49(2) of the Land Reforms Act. Patta lands cannot be transferred. Then, my lord, an application for annulment of patta was filed. That application was considered by the SDO concerned, and annulment order was passed. Then, my lord, they prefer an appeal before the appellate authority. Appellate authority also affirmed the order of the SDO. Now they file another application before the tribunal challenging the order of the SDO and the appellate authority. That is in pending. Now what I am on, but the school is the owner of the, at present moment, the school is the owner of the.
You are
plot.
for the school.
I am one of the parties of that proceeding. My application for annulment was filed by me, and on the basis of that, the order was passed.
Yes.
But suppressing all these things, my lord, this
I'll record these and keep this open in the proceeding, pending proceeding. You are entitled to take these points, definitely.
Yes, my lord.
Learned
Or
coun-
these
আর
suppression,
শুধু item 22 তে যা বললাম তাই হবে, তার সঙ্গে একটা জিনিস অ্যাড হবে। লাস্ট সেন্টেন্সের আগে accordingly such and such is disposed of এর ঠিক আগে এটা ঢুকবে। Learned counsel for the you are for respondent number
respondent number 8, 9 and 10.
for private respondent numbers 8, 9 and 10 submits that the petitioner comma in violation of law comma transferred the property in question comma despite the land being a patta land. Subsequently such transfer was set aside by two authorities comma against which an appeal is pending before the concerned tribunal. Full stop. As such comma it is argued that the petitioner cannot stake any claim to the property at all. Full stop. Next para. However comma such disputed question of fact cannot be entered into within the limited scope of the present writ petition comma which merely concerns the grievance of the petitioner that the petitioner's representation is not being considered by the authorities. Full stop. Hence comma without going into the merits of such allegations and counter allegations comma which are all kept open to be decided by the appropriate authorities if so raised comma the present writ petition can be disposed of in terms of the direction as given below. Full stop. Last line হচ্ছে disposed of directing conclusion ensuring conclusion of that proceeding within a limited period. Everywhere this is open to for you to challenge. You can take that. Definitely you will take that.
Or next matter, my lord.
23.
Yes.
24.
23. My lord, here, my lord, I am appearing on behalf of the private respondents. Here, my lord, writ petitioner suppress the fact that two earlier writ application was disposed of on the same cause of action.
Not disposed of, lordship, that was dismissed as
23
withdrawn.
এটা or
23.
That was dismissed as withdrawn, lordship.
My lord, kindly sees, my lord, here, my lord, first writ application was dismissed.
So they have suppressed that you are saying.
Yes.
No, no.
Yes.
That is also annexed in the.
Withdrawn with
petition,
leave to file afresh.
Lordship, that the
Last-
order is at page 17, lordship, that was withdrawn, dismissed as withdrawn. The issues were not decided, lordship.
My lord, last page of my lord's order,
Page
last
17,
page.
What
and
was the
it's
challenge
at
there?
Same
Lordship,
thing.
same lordship
Same
at
thing.
page 17 and it's the P3 lordship. That is dismissed as not pressed, lordship.
No,
The
but
issues were not
otherwise
decided,
this,
lordship.
you are
Yes,
right.
lordship.
If this was a cause of action,
Similar.
once arisen cause of action, then definitely they would be barred because there is no liberty to file afresh.
No,
But why is it not a continuing cause of action? They allege that there is illegal encroachment, which is
But-
continuing. If that be so, then it cannot be barred by this dismissal.
Yes, lordship.
my lord,
So it's not German then.
my lord, what happened, my lord? First writ application, my lord, which was withdrawn with liberty, my lord, that order have.
Second one, probably liberty not given.
There is no liberty and the
They have
same
annexed
cause
that.
of, same cause of action, same.
Suppressed, they have annexed. Their cause of action is their representation. They have given a representation that there is illegal occupation of the property by somebody, whoever. Now that illegal occupation, illegal or legal, that the authorities will decide, but that occupation is continuing till date. So it's a continuing cause of, their cause of action is not for eviction, your eviction. They cannot seek your eviction. The highway authorities can.
Yes.
Their cause of action is I have given a representation. The authorities are continuing to not take any steps thereon. So that's a continuing cause of action. The only direction which will be given here is that the authority, they have already initiated a proceeding.
But here there
Here
is
no proceeding has
no
been
proceeding is started.
So they'll have to take a call on that. I'll direct them.
My lord,
তাহলে আগের অর্ডার গুলো যেটা 24 পর্যন্ত হবে না, সেটা 21 পর্যন্ত হবে।
23 এটা।
23 টা আগেরটা বলে দিলাম যেটা।
22
প্রথমটা যেটা বললাম সেটা 24 পর্যন্ত উনি যেটা বলছিলেন সেটা 24 পর্যন্ত হবে না। সেটা জাস্ট ফার্স্ট দুটো 22 23 উনি যেটা আগেরটা বললেন, দিস ইজ 23।
This is 23, 22 is the.
22 তো আমি বললাম এক্ষুনি।
20
আর 23 টাও এটা যেটা বলবো সেটা হবে।
So what I am on, my lord, subject to, what I am on subject to approval, your lordships, my lord, these things, my lord, either they ought to have, my lord, file an application for supplementary.
They're seeking a consideration of a representation. They are saying it's unauthorized occupation. We are not going into that allegation. I cannot go into that. Can I?
One,
the authorities have an incumbent duty to act on it.
One after one, my lord, another application, another representation, they cannot file, my lord, on the same cause of action,
Opportunity for the learned counsel.
same cause of action, same plots
Nothing else.
within the same parties. This is my whole submission.
I'll record that definitely. Learned counsel for the private respondent submits that the petitioner is repeatedly going on filing one after another writ petition on the self-same cause of action. First up, the initial writ petition filed by the petitioner was dismissed as withdrawn with liberty to file afresh. First up, however, the subsequent writ petition was merely dismissed as withdrawn without any such liberty being given. First up, next para, it is argued that such facts have been suppressed in the writ petition. First up, next para, learned counsel for the petitioner, however, contends that the subsequent order of dismissal as withdrawn without liberty has also been annexed to the writ petition. First up, it is submitted that the merits of the issues have not been gone into by the court while so dismissing. First up, next para, although otherwise the private respondent might have had a valid objection as regards the suit, as regards the present writ petition being barred, since on the same cause of action, such principle does not apply in the present case, since the limited cause of action in the present writ petition is not on the merits of the allegations of illegal occupation, but on the dispute as to whether the respondent authorities are required to take steps on the representation made in that regard by the present petitioner. First up, next para, since the petitioner has made a representation and nothing comes forth from the respondent authorities as to whether any steps have been taken, WPA 13970 of 2021 is disposed of by directing the respondent authorities to consider the representation of the petitioner and take appropriate action thereon. First up, such action shall be intimated by the respondent authorities to the petitioner as well as the private respondent immediately thereafter. First up, such exercise shall be concluded as expeditiously as possible, positively within 4 weeks from the date of such 4 weeks from the date of communication of this order to the absentee respondents. First up, the petitioner shall serve a notice along with a server copy of this order on the absentee respondent in order to ensure compliance of the above direction. First up, it is, however, made clear that the merits of the allegations and counter allegations of parties against each other have not been gone into by this court, and it will be open to the parties to urge all points before any competent legal forum. No orders to cause certain state. All your points covered.
I should be given opportunity to place my case before the authority.
This is not your writ petition. In accordance with law, covers everything.
All right.
Thank you.
24.
20 and 24 are similar voting lots.
No, they are not appearing. Who is for the respondent? None appears for the respondent authorities, although the petitioner is represented through counsel. First up, the innocuous prayer made in the writ petition is that the petitioner's representation given to the respondent authorities, as annexed at page 11 of the writ petition has not yet been considered. First up, since the respondent does not appear to oppose the matter, WPA 2373 of 2022 is disposed of ex parte by directing the respondent authorities to consider the representation of the petitioner as annexed to the present writ petition as expeditiously as possible and in accordance with law, upon giving opportunity of hearing to all concerned, including the petitioner, positively within 6 weeks from the date of communication of this order to the respondent authorities. First up, the petitioner shall communicate server copy of this order to the respondent authorities, along with a copy of the writ petition containing the relevant annexure. comma, for the purpose of ensuring compliance. Full stop. No orders to cause urgency.
And Lordship, if any illegal encroachment is there, that to be removed by the respondent authority, Lordship. That to be pointed out, Lordship. If any illegal.
Cannot be removed. They'll have to take proceedings for that.
Yes, Lordship, in accordance with law. This
আচ্ছা,
shall take
একটা লাইন
action.
অ্যাড করে দাও ইয়ে অনিদিতা, সেটা হচ্ছে যে যেখানে WPS আছে ডাইরেক্টিং দি রেসপন্ডেন্ট অথরিটিস টু কনসিডার দ্য রিপ্রেজেন্টেশন, যেটা বললাম such and such, ওই সেন্টেন্সটা শেষে একটু অ্যাড করে দাও, and comma, if prima facie satisfied that there is illegal encroachment, comma, to initiate necessary action in due course of law on such score. তারপরের লাইন হচ্ছে যে petitioner shall serve copy.
25.
In this matter, I appear for the petitioner.
Yes.
This that specially assigned PMLA matter before your lordship.
This?
Yes, my lord. My lord, may I file my affidavit in reply?
Sufficiently
This is that
threatening.
matter of enforcement director, lordship has passed an interim order.
Why has it been assigned to me? Just it should be assigned to the regular bench.
My lord had passed the interim order dated 26th September. My lord, today I wish to file my affidavit in reply, and
I appear for the respondent number
Opposition you have filed, Mr.
I have received the opposition.
The opposition I am filing. 456.
My lord, my affidavit in reply. I've served them already on 11th April, my lord. My lord,
Yes,
my
yes.
senior Mr. Jishnu Chaudhary is appearing in this matter.
Fix it any day in the next week. They're enjoying interim order, any event. I appear for the.
Give me the date, Mr. Mitra.
Any day except 1st May, my lord.
Yes,
Mr.
except
Chaudhary
first.
isn't there.
There must be any day or after.
Affidavit in opposition and affidavit in reply filed today be kept on record. Full stop. On the prayer of learned counsel for the year for the respondent.
I'm for the petitioner.
I'm sorry. On the prayer of learned counsel for the petitioner, the matter is adjourned and shall next be listed on 2nd May. After the first week.
Yes, can we do on the 8th May?
Very well. On May 8, 2023. 8th May.
Grateful.
Regarding item number 24, my lord, lordship passed an order, my lord, for the state, madam.
Oh, no, I recorded nobody is appealing for the state. Now I cannot recall that. You have missed your bus. You have taken any steps on that? On the representation, you have taken any steps?
In accordance with law, your lordship passed order.
I have passed order. It cannot be.
My name.
No, your name cannot be recorded because I have recorded somewhere that none appears for the state in view of, and I have passed an order on that. Please don't embarrass me. Your name cannot be recorded in this matter. Open court, I have passed the order. Not now.